judges from the Supreme Court of India, Honorable Mr. Justice L. Nageshwar Rao, Honorable Ms. Justice Hima Kohli, as well as a very senior judge from UAE, His Excellency Justice Shamlan Al-Sweli, Court of Appeal Judge and Judge in charge of Arbitration Division at the DIFC Dubai. A very warm welcome to all of them. Our heartiest welcome to Mr. Sanjay Sudhir, Ambassador of India to UAE. Honorable Chief Justice, your presence here is an encouragement to the multitude of stakeholders who have collected here, jurists, lawyers, business leaders, and topmost arbitrators from across the world. And if there is some common thread which brings this diverse group together, is the desire to hear the vision of someone who presides over the largest judicial system in the world. You, as the Honorable Chief Justice of India. So, ladies and gentlemen, please welcome the Chief once more. Ladies and gentlemen, India is on the cusp of change and reform, and driven by the object to push for harmonious globalization and creation of an economic order which benefits one and all in India and those connected to India. Measures like ease of doing business, liberalization of FDI norms as some of the efforts in this direction. But a factor most important for a spin-off effect on economic development is the availability of an unprejudiced, secular, expeditious, inexpensive, flexible system of resolving trade and business disputes. Significantly, this ought to be a system which is accepted all over the world. Without doubt, the only mechanism which meets all these parameters is arbitration. A supportive yet non-interventional approach to arbitration is universally agreed to be the key to inspire confidence in the global business community. The judiciary, being one of the four legs of the great Indian democracy, can strengthen and facilitate this process. Ladies and gentlemen, there is only one person who can push this envelope. That is the Honorable Chief Justice of India, who is here with us today, a testament to his extraordinary support to the growth of arbitration. May I at this juncture request Mr. Subrakant Panda, Senior Vice President of FICCI, to honor the Chief Justice with a green certificate, a pledge by FICCI and ICA to plant 10 trees in his name in the vicinity of a prominent national park in India, the Sundarbans National Park. May I also request Mr. Panda to honor the Chief with an uttariyo around his neck. May now request Mr. Panda to deliver his facilitation address.
Mr. Justice N.V. Ramanna, Honorable Chief Justice of India, Honorable Judges of the Supreme Court, Justice L. Nageshwar Rao, Justice Hima Kohli, dignitaries on the dais, distinguished participants, ladies and gentlemen. Good morning to all of you. At the outset, let me express how honored I am to share the dais with the Honorable Chief Justice of India, Shri N.V. Ramanna, and be in the august company of senior judges of the Supreme Court of India and the many distinguished practitioners of this noble profession present here today. Honorable Chief Justice, I would like to commend you for your service to the nation. You have had a distinguished career and delivered path-breaking judgments which have strengthened the faith of the public in our judicial system. A large number of vacancies in the Supreme Court and various high courts have been filled during your tenure, and you will certainly be remembered for your immense contribution in strengthening the judiciary. It is difficult to conceive of a business environment where there are no disputes. Therefore, when disputes arise, it is in the best interest of all concerned that it is resolved in the quickest possible manner and at a reasonable cost. While the huge pendency of disputes are a dampener, the arbitration ecosystem in India has certainly been a redeeming feature. Even though I'm not a lawyer, but as a part of industry, I believe that arbitration is the most practical approach to expeditiously resolve business and commercial disputes. According to a study by White & Chase LLP, the 5 most preferred seats for arbitration are London, Singapore, Hong Kong, Paris, and Geneva. The common thread running through these centers are support for arbitration by the local courts, neutrality and impartiality of the judicial system, and track record in enforcing agreements to arbitrate, as well as the arbitral awards that follow. India, too, has witnessed significant growth in the field of arbitration, and various centers that have been set up are playing a crucial role in strengthening the system of alternate dispute resolution. This can be attributed to their smooth operations, the flexibility and innovation in procedural rules, besides, of course, the effort made to reach out to stakeholders through regular workshops and conferences. Speed and cost efficiency serve as benchmarks when it comes to determining the success of arbitration proceedings and are the reasons why arbitration is the more preferred choice for commercial parties and disputes rather than litigation. It is a common knowledge that as a seat for international arbitration, India is far more economical than many advanced countries which have prominent arbitral institutions. The effective enforcement of awards in the country has also been an attractive feature for disputing parties. Needless to say, this has been possible due to a healthy symbiotic relationship between the judiciary and arbitral institutions. I'm aware that the Indian Council of Arbitration and arbitral institutions in the country are doing noteworthy work. However, considering the backlog and pendency of cases in the Indian courts, there is a definite need to provide further impetus so as to increase overall efficiency in resolving commercial disputes, which will then allow the apex court and the high courts to focus on constitutional issues and matters which require interpretation of law. While the pandemic has certainly exacerbated challenges, as a nation, we have come out stronger. The apex court, too, has taken the lead in providing an effective system of administrative and logistical support for virtual hearings, which ensured that the wheels of justice kept moving. Technology is all-pervasive and will undoubtedly be an important factor in times to come. Innovations like artificial intelligence-driven platforms, which help in analyzing complex multi-party litigation, or simply in reducing the burden of judges when it comes to routine procedural matters, will soon be the order of the day. I'm sure the Supreme Court of India will be at the forefront of adopting technology without compromising on the basic tenet of delivering justice in an effective and impartial manner with a human touch. Ladies and gentlemen, alternate dispute resolution holds the potential to fundamentally change the way opposing parties look to settle disputes. It requires the right infrastructure, commitment, and an enabling environment. I have no doubt that India will emerge as a top arbitration destination, having made the right moves in this direction. With these words, I once again welcome the Honorable Chief Justice of India to this conference and wish the deliberations much success. Thank you.
Thank you, Mr. Panda. Your respect and faith in judiciary resonates among all the stakeholders. We are aware that as a senior member of FICCI Presidium, you have set a visionary agenda for FICCI to act as an instrument of nation building, including deep-seated judicial reforms. I'm sure the Honorable Chief will take cognizance of your suggestions. Ladies and gentlemen, the felicitation of the Honorable Chief is incomplete without a formal welcome address. And it would be most befitting that it should be delivered by someone who has given unflinching support to ICA for many years, Mr. N.G. Khetan, an eminent attorney, senior partner Khetan & Company, and president of ICA. However, before I request Mr. Khetan to deliver his address, I will request him to honor Mr. Sanjay Sudhir, Ambassador of India to UAE, with a green certificate. I will request Mr. Khaitan to deliver his welcome address.
Welcome to this fourth edition of our international conference. Honorable Chief Justice Sri Ramanna, Justice Chandrachud, who will be joining us virtually, Justice Nageshwar Rao, Justice Hima Kohli, His Excellency Sri Sanjay Sudhir, Ambassador to the UAE, Mr. Panda, our Vice President, Geeta Luthra ji, our Vice President of ICA, and Chawla ji, our Director General and now Advisor ICA, and now the Director General of WICI. Sir, Mr. Chawla has welcomed all the speakers, all our dignitaries, and it's a first time that we decided that, we must hold an international conference in Dubai. It was during our Golden Jubilee that we decided to have our first international conference, sir. And in that first international conference, sir, we had over 800 participants. That particular day, there was a ceremony in Rashtrapati Bhavan, a book opening ceremony, and our Chief Justice at that point of time had to suddenly go to Rashtrapati Bhavan. So he was 2 hours late. But then we had 800 spectators waiting for him and wanted to hear him and wanted to hear us. And he said that it looks like that the arbitration has actually arrived in India. And he was so happy that he said, you must continue with your international conferences. And that is what the comment Justice Thakur made on that day. And that is what gave us a thought and encouraged us that we must continue to hold our international conference apart from our regular seminars and conferences which we continue to have throughout the year. Sir, a lot of people are attending this conference for the first time. So I thought I also apprise some of the members present here about our ICA, and particularly you are also attending our conference for the first time. Sir, it was established in 1965, one of the first arbitral institutions in India, promoted by the central government, and it was also promoted by the central government with FICCI ASSOCHAM. And it starting progressing from time to time. The basic idea was that we must keep on promoting arbitration. As you know that, we had 1940 at that time, 1940 Arbitration Act. We were asking for various changes so that the arbitration keeps on progressing in India. Then our new act came into force. But what happened with our international conference, that it was so successful that in 2016 we had the BRIC conference. And we were requested by the finance ministry, Mr. Arunji, that ICA must organize a BRIC conference. And that BRIC conference, all the lawyers from various BRIC countries participated. And it was addressed by the Honorable Finance Minister and Honorable Law Minister also. Then again, we had our second edition of the conference, which was again inaugurated by the Honorable Chief Justice, Mr. Deepak Mishra. And again, in that conference, we had a large attendance. And the third conference was also inaugurated just before COVID by Justice Bobde. So therefore, it has been our endeavor to keep on having these international conferences. And all these international conferences were not only addressed by the Chief Justice, but by several Supreme Court judges, several international lawyers. In fact, in some of the conferences, there were international lawyers, 8 to 10 international lawyers coming all the way from different parts of the world and participating in this conference. So therefore, this has been a very, very great achievement as far as the ICA is concerned. And what has happened that today we have opened 11 centers of ICA. And we have a cooperation treaty agreement with about 47 countries around the globe. So basically now ICA, I would say, is one of an international arbitral institution having a cooperation agreement with 47 countries and having 11 centers in India. So it's a big achievement for ICA, and it has already been possible with the support of the judges of the Supreme Court, lawyers coming from all over the world and participating, which encouraged us that our job is now to promote arbitration in India. Sir, in our first international conference, which was addressed by Justice Thakur, he made a very startling statement. He said that there is no conflict of interest between judiciary and arbitration, and to arbitrate is a divine function. What a statement. And in the second edition, the Chief Justice, Justice Deepak Mishra, said, I will quote him, that we must promote institutional arbitration and shun ad hoc arbitration. And in the third edition, Justice Bobde came out with again a very encouraging statement, and he said, and Justice Nageshwar Rao is here, so this will make him happy. An ounce of mediation is worth a pound of arbitration and a ton of litigation. What a statement. I mean, today we are coming out with a new mediation law. And in one of our conferences, Justice Nageshwar Rao was also there, and he asserted that we must promote mediation, and it is not only cheap, but a speedy way to resolve our dispute. That is why I quoted that what Justice Sharad Bobde said, that an ounce of mediation is worth a pound of arbitration and a ton of litigation. And Justice Himaji has been with us on many occasions. I mean, she has participated in our conferences as a judge of the Delhi High Court, and now she is participating as a judge of the Supreme Court. And she again made a very bold statement. And she said that the arbitration has arrived in India, it has matured, and has now received a judicial acceptance. So thank you, Himaji, for that wonderful statement. Sir, we have over 50 arbitral institutions in India, and recently you inaugurated the Hyderabad one, Delhi court has one. And in our BRIC conference, we realized that, in some of the countries, even a country like Russia, they take just 3 months for enforcement of award. And when I was talking to the Chinese lawyers, they said that in China, there is no provision for ad hoc arbitration. It's all institutional arbitration, and there are over 300 arbitral institutions in India. So these statements really encourages us, because we feel that India today, it's the 21st century belongs to India, and Niti Aayog recently has came out with a very bold statement as to a paper on the online dispute resolution. Today is the virtual world, so therefore online dispute resolution is one of the way where through video conferences we do arbitration in Singapore, to all international arbitrations. We don't have to go to the different countries. So this online arbitration has matured. Sir, why India? Why India? I mean, look at India today. Sir, everybody will be surprised that in 2021, this is very important, that 16,500 companies were registered in India during COVID times. I myself not aware of it. I took this figure, that during COVID time of 2021, 16,500 new companies were registered in India. This shows that how India is progressing. The world is recognizing India. In fact, we had 81 unicorns in COVID times, which is the third highest in the world. And there was a report that we have the fourth largest think tank in India. And it is the third largest, India is the third largest contributor to the global growth. During COVID time, we have been the fastest growing economy of the world. And next year also, our projection is that we will be the fastest growing economy in the world. So why should we lag behind as far as the arbitration and mediation is concerned? Why did we choose Dubai? Sir, it's again very interesting. One of the person was asked that, which city in India do you live in? And he said, I live in Dubai. And you gave the other day the conference that 3.5 million individuals lived in Dubai. Our ambassador is here. Dubai alone has 1/3 of the Indian population is in Dubai. The prosperity of Dubai, to a great extent, the Indians have been a great extent. And Dubai we have recently concluded a free trade agreement with Dubai. Very few countries we have the free trade agreement. So we thought this is the right place. to have this our international conference. And I'm sure with the people and the participants present here, you can see so many people. Many people have flown all the way from India to join in this conference, to participate in this conference. And in one of the conferences, you said that recently I read that there was an award, international award, and you said it's going to cost 5 crores rupees as the cost is concerned. So I'll be happy to announce, sir, that as far as the ICA is concerned, our administrative cost beyond 20 crores is only 7,51,000, and the maximum fees, irrespective of the amount, our administrative cost is 25 lakhs of rupees. So it's not 5 crores, which you were very, very concerned that in the international arbitration, which is being held in Paris, the administrative cost was 5 crores of rupees. Sir, as far as I would like to say that one of the points which you said was why do we have this arbitration in Dubai? Because Dubai has really progressed as far as the arbitration law is concerned, sir. In fact, we are holding a conference in the 19th of March. And Sudhir would be aware that they are coming out with new arbitration rules as early as after, I think, 22nd of March. And then they have these provisions of third-party funding. They have this provision of emergency arbitrator. Then they have this provision for expeditious arbitration, where the award would be given within, same like our provision. So we lack one or two things, but will of course come in. But these are the very innovative things which the Dubai has done. And we felt that it is a right place and a right center to do the arbitration. And sir, recently, I think I would like to inform everybody, recently the Union Law Minister, Mr. Kiran Raju, while speaking at an event in Greater Noida, said that the Chief Justice of India, Mr. N.V. Ramanna, has a man who has strengthened judiciary, and that such a judge is a true blessing for the country. I think it needs an applause, please. Sir, you are also very concerned about the woman empowerment. I am happy to inform you, and I think the 21st century actually will not belong to us, it will belong to women, sir. In my office, I have over 700 lawyers, sir, and 35% of the lawyers today are women. 35%. The other day I was speaking in one of the conferences, the first year student in a law school, and I asked them that what is the percentage, men and women. He said, we have more girls. The percentage of girls having admission in law college was more, where I was introducing what they should do in life as far as their admission to law is concerned. There were more girls. In our office, when we have interns, we have more girls interns than boys interns. So that the 21st century will belong to Geeta ji, will belong to Pinky ji, all these people will be ruling it, and we will have a second seat, sir. You can take it from me. Sir, I'm 100% sure, I mean, the way we are proceeding, the way we are things, the way we have evolved ourselves, we will succeed. We are determined to make India as a hub of international arbitration. In fact, sir, you recently quoted, while you were in Hyderabad, and you said, and you quoted Prime Minister of India, and you said that any democracy worth the name must provide for adequate and effective means of dispute resolution at reasonable cost. Otherwise, the rule of law becomes a platitude, and the people may take law into their own hands, disrupting peace, order, and good governance. So this is what he quoted, Prime Minister of India. I think this also needs an applause from you. I mean, this is how you should go forward. I would also like to recognize, sir, today we have 5 speakers coming. They have come all the way from London. Then we have 3 speakers who have come from, 7 speakers are from Dubai. 3 have come from India. May I request you to please stand up, please? All the speakers who would be participating. So they have come all the way from different parts of the world. So I think it needs a round of applause from all of you. Sir, I don't need to speak about robust arbitration law because we have many sessions here and they will be speaking about the arbitration law and how we have progressed and why should we not arbitrate in India. As you said that we are very cost effective. Our arbitration law is very positive, very innovative. And I'm sure with this conference, more people situated in Dubai would also, this is actually an international hub. It is after the New York, people say the next international city is Dubai. And so we are so lucky that we are today in the second international city to promote arbitration in India. And I'm positive and confident that the people in Dubai, the commercial world in Dubai would consider India and would try to choose India as their venue of arbitration. And lastly, sir, I would like to thank the Secretariat, FICCI Secretariat. I would like to thank the entire FICCI Secretariat, Mr. Chawla, without whose help this conference was not possible. I would also like to recognize the presence of our former Solicitor General, Mr. Ranjit Kumar. Thank you very much, sir, for being here. We had additional Solicitor General, Pinky ji is here. Thank you, Pinky ji, for being here and agreeing to become one of the speakers. And I don't know whether Mr. Kubi is here or not, but I would like to also thank him, the Consul General of Emirates. He was of Dubai. He was here. And thank you all for being present here. Thank you very much. Thanks a lot.
Thank you, Mr. Ketan. You have, as usual, been very candid in your approach. The COVID-19 pandemic has taught us many benefits, particularly of institutional arbitration, and to the entire stakeholder community across the world, and India is no exception. As we move towards the post-pandemic era, we will surely see institutional arbitration overtake all other mechanisms of resolving commercial disputes. Yes, in India, ICA has been in the lead to reinvent and use technologies to overcome constraints. Incidentally, ladies and gentlemen, I'm delighted to share that we have over 4,000 participants who have logged in through the social media platforms. So, ladies and gentlemen, in this era of globalization, the diplomatic community plays a tremendous role in building the practices and cultures of nations, as well as bringing them onto platforms which are seamless, as well as investment across boundaries. Shri Sanjay Sudhir, the Honorable Ambassador of India to UAE, has many such laurels to his credit, including the recent signing of the CEPA agreement between India and UAE, which we foresee will push the mutual trade to go up from 60 billion to 100 billion in the next 5 years. Dollars, I'm talking in terms of dollars, US dollars. Dispute resolution and, most importantly, arbitration will play a significant role in this ambitious journey. Honorable Ambassador, we are fortunate to have you with us today. May I request you to share your views and make your very special address. Thank you.
Honorable Chief Justice of India, Justice N.V. Ramana, Justice Nageshwar Rao, Justice Hema Kohli, dignitaries on the dais, distinguished guests, ladies and gentlemen, good morning to all of you. I'm indeed delighted to be a part of the 4th edition of this International Arbitration Conference organized by ICA and FICCI. I must congratulate both the organizations to bring together such a wide array of legal luminaries from different parts of the world with wide-ranging experience connected to arbitration. It's indeed an honor for us to have Chief Justice of India and Supreme Court judges in our midst. Being the first official visit of a Chief Justice of India to the UAE, his visit is a historic visit, connecting a key pillar of governance of our two countries. Besides, his presence in this conference will certainly give a very concrete impetus to our collective efforts in the field of arbitration, and in particular, as Mr. Ketan mentioned, to make India the next hub of international arbitration. The topic of the conference, arbitration in an era of globalization, I think holds special interest for both India and the UAE in the light of the signing of the Comprehensive Economic Partnership Agreement, CEPA, as we call it in short, exactly a month ago. CEPA is not just about trade, it is FTA++, and moves in the direction of integrating our economies. And we are talking about the sixth largest economy in the world and the second largest economy in the Middle East and North Africa region. CEPA is expected to give Indian industry much better market access into Africa, into Asia, and other parts of the world. And we expect that sectors such as gems and jewelry, textiles, leather goods, pharma products will benefit enormously for India, while the UAE hopes to get enhanced market access to a huge market which is there available in India for its petrochemicals, metals, and dates. India and the UAE trade, which hovered around 60 billion in pre-COVID years, as Mr. Arun Chawla just mentioned, we are reasonably certain that it should rise up to about 100 billion in the next 5 years. Enhanced trade flows and also new opportunities will surely be followed by larger investment flows. The environment of enhanced trade and investments may give rise to commercial disputes between Indian and UAE entities. And as Mr. Shubhrakant Panda also mentioned, that it's very difficult to conceive of any business environment where there are no disputes. Given that, I think it's very important to have some kind of a fast track, some kind of a cost-effective, time-saving mechanism to settle these disputes. Over the past few years, there have been many notable developments in arbitration in the Middle East. The growth in the economy and international trade of this country, the UAE, and more generally in the region, has brought with it increase in dispute resolution offerings. Parties are becoming increasingly willing to have their disputes resolved through the mechanism of arbitration. Equally true is that arbitration ecosystem in India has also benefited a great deal from the range of steps taken by the government. It's a matter of encouragement for the foreign investor community that arbitral awards are being less and less challenged. I can share with you that a couple of days back, Honorable Chief Justice of India, in his meetings with the Justice Minister and Chief Justice of the UAE, has already discussed issues which could actually help in enforcement of arbitral awards in our two countries. I'm glad that ICA and FICCI chose Dubai as a venue for this conference. Some of the areas have already been highlighted by Mr. Khetan, but I must also add that Dubai is certainly a very special place in today's day and age. And we have all seen it during COVID times that when global economy looks depressed, this city has the courage, I would say, to host World Expo, and with great aplomb. I mean, the World Expo, which is happening right now in Dubai, is perhaps the largest World Expo with the largest footfall, and that also in very difficult COVID times. When connectivity is breaking down, the airlines of this country are actually connecting countries of the world and moving people from different parts of the world to other parts. So this definitely is a very active hub, as it has proven itself. Also, India is today UAE's second largest trading partner, and UAE is India's third largest trading partner already. And our bilateral trade and investments is an area where we expect most dynamism in the times to come. I'm sure that ICA's conference will provide a platform to address key issues concerning international arbitration, and will also facilitate exchange of insights and experiences in perfecting the current arbitration regime both in India and overseas. I wish the participants of this conference all the very best. I'm sure deliberations will contribute in making India a hub for international arbitration. I thank you all for being here.
Thank you, Ambassador Sudhir. Your statement will not only hasten the process under the CEPA, but will give added confidence to the business community on either side to collaborate, trade, and make this agreement as an example of nations coming together for a mutually beneficial relationship. Ladies and gentlemen, let me now turn to someone who has had a track record of over 17 years as a leading advocate, next 22 years in the judiciary, having acted as the Chief Justice of Andhra Pradesh, Chief Justice of Delhi High Court, before being elevated to the Supreme Court of India in the year 2014, and having assumed the revered position of the Chief Justice of India since April 2021. Some of his key initiatives have had far-reaching impact on judicial administration, improving court efficiency and widening access to justice. Someone who is a reformist by nature and appreciates the need to augment the strength of judiciary, he has filled vacancies across high courts in India, as well as more than 9 vacancies in the Supreme Court. Someone who believes in transparency, having held by way of his landmark judgment that office of the CJI comes under the purview of Right to Information Act. Someone who encourages mediation between parties rather than exercising adversarial dictate of the court in all situations. Someone who's sensitive to the needs of the greater 50 and hence strongly advocates for reservation of women in the judiciary and other careers. Ladies and gentlemen, I can go on endlessly, but it's time to hear this someone, none other than the Honorable Chief Justice of India, Justice N.V. Ramanna. Please welcome him while I request him to deliver his remarks.
Brother Justice D.Y. Chandrachud, who has joined us online. Brother Justice L. Nageshwar Rao, Sister Justice Hema Kohli, the Honorable Judges of the Supreme Court of India, His Excellency Justice Shamlan Al Sawalehi, Honorable Judge, DIFC Court, Dubai, Mr. Sanjay Sudhir, Ambassador of India to Arab Emirates, Mr. Arun Chawla, Director General FICCI, Mr. N.G. Kaitan, President ICA, Mr. Subhakant Panda, Senior Vice President FICCI, Ms. Geeta Lodra, Senior Advocate and Vice President of ICA, distinguished guests, panelists, experts in the field of arbitration who have assembled here, other distinguished guests, friends from legal fraternity, friends from media, friends from other parts of this country, ladies and gentlemen, good morning, namaskar. I am happy to be participating in this event physically. It's been almost 3 years I last attended such an international event. There is a different energy that I can feel here, which could not be replicated in an online setup. The theme chosen for this event is arbitration in the era of globalization. I am glad that FICCI and the Indian Council of Arbitration have brought together eminent experts to deliberate upon pressing issues in this field of law. FICCI and ICA are doing a commendable job in making India a favorable destination for all investors and businessmen. India's investment forum and is actively contributing to the pursuit of meaningful engagements. It has been in the forefront of garnering opportunities for Indian businesses and startups. Similarly, ICA is one of the leading arbitration institutions in South Asia and is dedicated to the cause of quick and inexpensive justice. The choice of venue for this conference is inspired. Dubai, in the last 2 decades, has transformed itself into a preferred arbitration destination for Asian countries. It is the best suited to host such a conference. The world today is very different from when I started my profession in the year 1980s. Countries across the world have moved from being protectionist state to open economies. This has been immense growth in trade and commerce between countries. In the 1980s, the total value of world trade stood at around $2 trillion. In 2019, the value of global trade was more than $19 trillion. This clearly shows that there has been rapid growth in the world trade over the past 4 decades, and the trend suggests that it shall grow further. Advancements in the field of science and technology, easier travel, and faster communication have turned the world into a global village. At the same time, the enhanced interdependency also makes us vulnerable. crisis one part of the world often creates ripples in other parts and can affect the global supply chain. From time to time, conflicts between territories, environmental changes, natural calamities, even the ongoing pandemic have resulted in economic disturbances. Such disturbances tend to leave a lasting impact on global trade. We live in a closely knit world, yet we continue to be sovereign nations, having our own independent legal regime. Each nation has to legislate, keeping in view its past and socio-economic conditions. Different nations, therefore, regulate issues like intellectual property rights, taxation, and tariffs, cryptocurrency differently. And any and every effort to evolve a universally acceptable mechanism for dispute resolution must be alert to the reality. Harmonizing diverse interests while trying to achieve a common goal is a huge challenge. It is in this context that conferences such as today will help us navigate the path smoothly. The globalized world demands embracing a dispute redressal mechanism that is acceptable and fair to everyone. Fairness demands a platform where both parties get an equal say in the resolution of their dispute. This is where international arbitration comes into play. Arbitration is the best suited dispute resolution mechanism for the globalized world. International arbitration is a party-driven, has procedural flexibility, and involves domain experts. Further, arbitration is a time-bound mechanism structured to deliver immediate relief. No one should be able to say about arbitration that an American jurist, Evil Anger, said about traditional litigation. I quote, "An incompetent lawyer can delay a trial for months or years. A competent lawyer can delay one even longer," unquote. This brings me to the aspect of uniformity and stability in the dispute resolution process. Parties should be confident that an award rendered by tribunal is in one nation will be executable in another without any hassle. To meet this goal, nations around the world have attempted to create effective structural mechanisms. Efforts were made to ensure that arbitration becomes a popular mode of dispute resolution. To increase the faith of parties on the arbitration framework of a nation, adequate statutory backing regarding enforcement of awards is necessary. Interim measures of protection are also important. It might be relevant to mention that when it comes to the enforcement of foreign decrees, different countries follow different procedures for recognition and enforcement of the same. India and the United Arab Emirates have entered into a reciprocal arrangement in 2020 to opt for automatic enforcement of foreign decrees by courts of either countries. This is a special procedure meant only for decrees from specialized reciprocating countries, which form a part of the schedule of recognized countries under Section 44A of the Code of Civil Procedure in India. Apart from the United Arab Emirates, India has entered into similar understandings with United Kingdom, Singapore, Bangladesh, Malaysia, Trinidad and Tobago, New Zealand, and Hong Kong, among others. I think it is necessary to mention at this juncture another form of dispute resolution, that is mediation. Mediation is increasingly gaining performance in the international commercial sphere. Rebate mediations, which take place at the pre-litigation stage, are also becoming more prevalent in the country. Most arbitration clauses in commercial contracts have a multi-tiered approach, where the first attempt to resolve the dispute between the parties through mediation or negotiation. As the famous author R.L. Stevens once said, I quote, "Compromise is the best and cheapest lawyer," unquote. Modern arbitration law in India can be tracked back to 18th and 19th century laws, which are the Bengal Regulation Act and the Madras Regulation Act, where parties to the dispute could submit themselves before an arbitrator. For the first time in 1940, we had a Pan-India Arbitration Act. Meanwhile, in 1985, keeping in view of the increasing cross-border transactions and disputes arising thereof, ANCITRAL came with the model law on international commercial arbitration. In India, with economic liberalization, a need was felt to provide a viable alternative for parties, both national and international, to resolve their commercial disputes. The Arbitration and Conciliation Act 1996 was enacted in line with the model law with the hope to provide an effective alternative to court-based resolution. It is appropriate, again, I remember, P.V. Narasimha, the then Prime Minister of the country, during the inauguration of the International Conference on Alternative Dispute Resolution in Delhi 26 years ago, what he said, I quote, "Any democracy worth the name must provide for adequate and effective means of dispute resolution at a reasonable cost. Otherwise, the rule of law becomes a platitude and people may take law into their own hands, disrupting peace, order, and good governance. Effective dispute resolution is also necessary to secure the smooth functioning of trade and commerce," unquote. To make the arbitral process more effective and to bring it par with the international law and on arbitration, the Arbitration and Conciliation Act of 1996 was amended in 2015, 2019, and 2021. Wherever I travel, I often was asked a question as how investor-friendly the Indian judicial system is. My answer is always the same. You can trust the Indian judiciary for its absolute independence and its inherent constitutional strength to treat all parties equally and equitably. A prerequisite for achieving globalization in its true sense is ensuring universal respect for the rule of law. Trust in the globalized world can only be built by creating institutions with a strong emphasis on the rule of law. Rule of law and arbitration are not in conflict with one another. Both arbitration and judicial adjudication aim to serve the same goal, to pursue justice. The Indian courts are known for their pro-arbitration stance. Courts in India assist and support arbitration and leave the substantive part of adjudication to the arbitration tribunal itself. A crucial component of attracting investors in providing a stable and efficacious mechanism for redressal of disputes. The legislature, executive, and the judiciary of India at all levels are committed to improving the arbitration landscape and the ease of doing business in the country. The Commercial Courts Act enacted by the Indian Parliament led to further streamlining the speedy dispensation of justice in commercial matters. Promoting a culture of arbitration is not a simple task. Having a pro-arbitrational jurisprudence and policy is not enough. Some innovative steps must be taken in this regard. After examining various cases, I find that governments and the parties often take the stand that the agreement initially entered into it void or incapable of execution because it is against public policy or against law. To avoid such belated objections, it is high time to evolve some special mechanism. One such special mechanism could be pre-vetting by specially constituted authority of the state prior to the parties entering into any commercial or investment agreement. No way I am suggesting that such a step is mandatory. It would be completely voluntary. Such a vetting process would, of course, be subject to the consent of the contracting parties. This would ensure fewer disputes arising at the execution stage on the nature and sanctity of the agreement and on public policy grounds. I think it is high time to have detailed deliberations on this issue. I request particularly the third panelist, Justice Seema Kohli, has to look into this issue and can make some suggestions. With the experience I gained in the field, I would like to suggest a few essential prerequisites for arbitration to effective and successful. First one is scope for judicial interference from pre-reference stage to challenge an award needs to be minimized. 2, timelines for completion of arbitral process should be strictly adhered. 3, execution of arbitral awards needs to be ensured. 4th, autonomy of the party should be respected. 5, mechanism for regulating the arbitral fees has to be in place. 6, grounds for challenge to the arbitral award should be limited to the bare minimum. 7, Granting of a stay on arbitral awards should not become the norm. 8. Emergency awards should be accorded recognition. 9. Focus has to shift to institutional arbitration. 10. To meet ever-increasing demands, more and more arbitration centers should be promoted. 11. Institutional mechanism need to be promoted to attract the services of eminent panelists and professional arbitrators. It adds to the credibility of the process. 12. New technologies should be put to use while promoting online interface and proceedings. 13. The practical knowledge of the arbitrator will be a key factor and accordingly needs to be given due importance. 14. Robust training programs need to be created for training of young professionals. Several international dispute resolution institutions are becoming established across India to provide the commercial world speedy and effective resolution of their disputes. Recently, I, along with my brother and sister judges sitting here, and a few other eminently qualified professionals have been involved in the setting up of an international arbitration center at Hyderabad, Telangana. The state of Telangana has been very encouraging and supportive of this endeavor. Though this institution, we are looking to create an independent body which is self-sufficient and delivers to the international standards. The government of India also made a provision in the latest budget for setting up an international arbitration center in the state of Gujarat. I strongly believe that there is a lot of potential for setting up such new centers. To meet the increasing demands, they will have to cooperate rather than compete. As these centers are new and upcoming, there is a lot of to be learned and shared. I hope that the Dubai International Arbitration Center and the international arbitration centers in India will cooperate and share information and knowledge. I see a future both in India and Dubai tending towards institutional arbitration. I am sure the 4 different sessions to be chaired by Brother Justice D.Y. Chandrachud, Justice L. Nageshwar Rao, Sister Justice Hima Kohli, and His Excellency Justice Salman Ali Shavali, with the participation of highly qualified panelists, will be enlightening and stimulating. I am confident that the discussions and debates will result into the ideas that can fruitfully employed in our respective jurisdictions. I wish the event a grand success. Before I conclude, I must place on record my sincere thanks to Mr. Arun Chawla, who did not give up even after the pandemic forced him to abort the event scheduled to be held in the month of January. But for his relentless efforts, this conference would have not been materialized. I congratulate him and his team at FICCI for taking up his brilliant idea to its logical conclusion. I must thank Mr. Anji Kaitan of the ICA and his colleagues for investing time and energy to make this event a success. The Ambassador of India to Arab Emirates, Sri Sanjeev Sudhir, and the Consulate General of India in Dubai, Dr. Aman Puri, and their team have extended all necessary assistance to me and my colleagues from the Supreme Court. Right from the time we landed here on the 16th, we are received and hosted with warmth by people from all walks of life. I thank each one of them. Thank you very much for giving this opportunity.
What a powerful statement from the Honorable Chief Justice of India. Arbitration is the best suitable mechanism for resolution of international disputes. Honorable Chief, you have also committed that the judiciary at all levels is committed to promoting a culture of arbitration. Ladies and gentlemen, a thought-provoking address and a message to the international community present here that India is ready with the mindset and infrastructure to resolve any international commercial dispute with the least of the hassles and the cost. Honorable Chief, you mentioned mediation as a pre-litigation mechanism of resolving disputes. You will be happy to know that Indian Council of Arbitration endeavors with the parties to first resolve their dispute through mediation before going to arbitration. Ladies and gentlemen, this is an encouraging statement by the Chief. So set your eyes on India as a destination to resolve disputes, and I assure you that the Indian Council of Arbitration will be there to facilitate all possible glitches that may arise in your commercial ventures with your Indian partners. Ladies and gentlemen, it's time to conclude and propose a vote of thanks. May I therefore request Ms. Geeta Luthra, Senior Advocate, Supreme Court of India and Vice President, ICA, to do the honors.
I have the most pleasant task and most delightful task of thanking all of you for being here. Honorable the Chief Justice of India, Honorable Justice Chandrachud, though virtually present, Honorable Justice Nageshwar Rao, Honorable Justice Hema Kohli, His Excellency Justice Shamlan Swalahi, His Excellency Mr. Sanjay Sudhir, my colleagues, Mr. Panda, Senior Vice President, FICCI, Mr. N.G. Khaitan, President, Indian Council of Arbitration, and partner, Senior Partner, Khaitan and Company, Mr. Arun Chawla, Director General, FICCI, and Advisor, Indian Council of Arbitration. Distinguished dignitaries, we have an ex-Solicitor General of India, Mr. Ranjit Kumar, present among us. We have Ms. Pinky Anand, again, ex-Additional Solicitor General. We have Jayant Sood, Additional Solicitor General, and various speakers who, of course, you will see their erudite contribution to the conference as the day goes by. As Vice President of the Indian Council of Arbitration, I thank each of you for having joined us on this special occasion. Despite the pandemic, the last couple of years has seen a huge growth in the arbitration law and jurisprudence in India. We've also seen huge number of matters going into arbitration, something which perhaps we did not expect due to the pandemic. But pandemic has seen all over the world, including in India, a growth of arbitration law, arbitration jurisprudence, and arbitrations, and that is a very encouraging sign. Justice B.N. Shri Krishna, Supreme Judge, retired Judge, Supreme Court of India, in his report of the High-Level Committee to Review Institutionalization of Arbitration Mechanism in India, has said that the very reason, one of the foremost reasons why parties choose a particular arbitral institution is the arbitral rules that apply as a result of such a choice. It is in this regard that various arbitration institutions in India, including the ICA, have world-class laws and world-class rules, and India has emerged as a hub. We have seen various judgments, several of them delivered by all the learned judges who are present today and who would be chairing various sessions. The Honorable Chief Justice of India, on the issue of arbitrability in the Vidya Drolia case judgment, which was followed by NN Global, has spoken about arbitrability and overruled an earlier judgment where it said tenancy, landlord-tenant disputes, agreements of leases are not arbitrable. That and various other aspects with regard to trademarks, copyright, patent law while excluding judgments in rem, have been something which we can only say that that judgment has been a path-breaking judgment, which we are quoting every day in the courts. An interesting judgment introduced of Justice Nageshwar Rao in Delhi Airport Metro Express case has again repeated the contours of Section 34 and what disputes and what matters may be, objections may be raised to awards, and the scope has been extremely narrowed. He has also elaborated on the fundamental policy of India in this context. Justice Chandrachud's encouragement to young lawyers, saying that they would make good arbitrators, was something that was applauded world over and would perhaps be path-breaking. In UHL Power Company versus State of Himachal Pradesh, authored by Justice Kohli, the Supreme Court said, merely because another view could have been taken can hardly be a ground for a judge to interfere with an arbitral award. The issue of party autonomy has also been discussed in several recent judgments. It's interesting that all these judgments are of late 2020, 2021. So you'd see how the law is evolving, it's developing, and how India has become investor-friendly for alternate dispute resolution. I would be failing in my duty to not note the judgment of His Excellency Justice Shamlal Swalihi in multiplex constructions, where he discussed the issue of a party coming to the onshore courts of Dubai, trying to get out of arbitration, and he obviously ruled that the invalidity of onshore court proceedings when matters and when there was a valid arbitration clause. Now, coming to the issue of mediation, there is a mediation bill which has been introduced in Parliament. Rajya Sabha has passed it, Lok Sabha is considering it, Parliamentary Committee is sitting on it in the meantime, and there are many interesting issues. Should mediation be compulsory? Should it continue to be voluntary? Should the mediator, arbitrator be a person with a single hat, or will there be two different hats or two different persons? These are interesting aspects. I end with quoting Mr. Fali Nariman and hoping that we can depart from what he said. He said that the future of arbitration is bright, but only because the future of litigation is not. I can only pray and hope that the future of arbitration is bright because it is bright, and may it get brighter and brighter. Thank you, all of you, for being here. Thank you for your presence, and let's look forward to the sessions ahead. Thank you so much.
Thank you, Geeta. Ladies and gentlemen, we'll break for 10 minutes for a cup of tea and then come back to a very interesting session after this on the challenges of arbitration that we face. Thank you.
पहले किया था मिस कॉल दिया We are going to start our next session. Kindly be seated, please. Thanks.
You are there, no? You sit. Good afternoon, ladies and gentlemen. Once again, I warmly welcome you to today's conference. A wonderful start. We had a good inaugural. We are now excited to move into the focus sessions, starting with the very first session, Challenges in Cross-Border Disputes, Way Forward. We have with us a panel of seasoned speakers, chaired by Honorable Justice L. Nageshwar Rao, Judge, Supreme Court of India. Please welcome them on the dais. Justice Rao's elevation to the Supreme Court directly from the bar speaks volumes about his contribution to the legal field in the country. Prior to his elevation, he has been a senior advocate with a track record of having served for 2 terms as Additional Solicitor General. Being the trustee of the International Center of Arbitration set up in Hyderabad, he has shown immense faith in arbitration as a mechanism for solving international disputes. Before I hand over the session to Honorable Justice Rao, may I request Mr. Khetan to honor him with a green certificate. The O3O as well. I will now request Justice Rao to deliver his keynote and lead the session thereafter. Thank you.
Good afternoon, ladies and gentlemen. Though I'm shown to be delivering a keynote address, as you have experienced speakers, I would just be touching on a few points before I request the speakers to make their presentations for today. To start with, let me introduce the speakers to you in the order in which they're going to speak. Mr. Thomas R. Snyder is a partner and head of arbitration at Al Tabibi company in Dubai. Mr. Ganesh Chandru is a partner at Dua Associates, specializing in international and domestic arbitration as well as commercial arbitration. Mr. Daniel Wilmot, he is a partner in the international arbitration team at Stewart's, which is the UK's largest disputes-only law firm. And you have Ms. Olena Voronovich, who is a senior case manager at the DIAC, who is replacing Mr. Rashid Shaheen from the DIAC. Before I request the speakers to share their thoughts. Thank you. I congratulate FICCI and ICA for bringing us all together today to deliberate on the challenges to cross-border disputes. With the growth of business and globalization of the economies, especially India, commerce has increased multifold, and the necessary corollary of any growth would be disputes. And dispute resolution would be also following suit, which is the best way of resolving cross-border disputes. At the study conducted in 2021, according to Queen Mary's College, more than 90% of the respondents have preferred international commercial arbitration as the preferred manner of settling their disputes. Like any other system, however well it's working, there are bound to be challenges. And it's good that these challenges are discussed at fora like this so that we find a way forward and a solution to the problems that international commercial arbitration is facing. You must have seen the background note that is given to all of you. There are two aspects that are mentioned in the background note. One pertaining to the arbitrability of disputes, and the second relating to emergency arbitrations. I will not be saying anything further on those because you have a note that has been given to you on these two topics. Arbitrability of disputes has been dealt with by Geeta Luthra in her vote of thanks, where she was referring to the law in India initially that disputes in rem were not arbitrable, and the change that has been brought about by recent judgment of the Supreme Court, where certain disputes which are in rem are also arbitrable, like a tenancy dispute, patents, etc. I should be very frank in telling you that at some point of time, India was not seen to be a pro-arbitration country. I remember a long time back, about 22 years back, I attended an arbitration conference in Sydney. And during the course of discussions that were held there, what not to do in an arbitration was with reference to India. But times have changed. Even the dispensation at the executive as well as the parliamentary regime has taken note of the fact that arbitration has to be strengthened for various reasons. One of the main reasons which is being faced in India, where access to justice is available to everyone to a large extent, has increased the number of cases that are filed in courts and the number of cases that are pending in courts. Arbitration, initially under the 1940 Act, was seen to be a step to go ahead and then file another suit. Things have changed with the 1996 Act, where the ancestral model has been adopted. But there were drawbacks in the implementation of the 1996 Act also, which was realized by all concerned, and the advent of the amendments that were made to the Act in 2015, and thereafter a HEPOUT committee which was appointed by the government, which submitted its report in 2017, which has encouraged institutional arbitrations to be definitely a way forward, which culminated in the 2019 amendment that was made to the Arbitration Act. Though a few amendments which were made have not been notified, which I hope would happen sooner, the other amendments have come into effect already. I would like to say a few words on the supervision of the courts in matters relating to arbitration and the enforceability of awards, international commercial arbitration awards in India. At the stage at the interlocutory stage when an arbitration is pending, insofar as the domestic arbitrations are concerned, applications that are filed for injunctions, etc., were to start with a little difficult to digest because the arbitrations themselves were being postponed in view of unwarranted interference by courts. That has been taken care of. By and large, you would see that the interference by the courts during even domestic arbitrations has been very limited at the present point of time. But still, I am of the personal opinion, even at the domestic arbitration levels, that there should be dedicated courts at the lower rung of the courts as well as the high courts for commercial matters to ensure a speedy resolution of dispute at the supervisory stage by the court. That would definitely be helpful. And you also need trained judges. As most of you are from India, I'm taking the liberty of speaking about even domestic arbitrations. You would see that judges who are handling various subjects would find it a little difficult to understand how to go about a dispute arising out of an arbitration. They would treat this as another matter coming from litigation. So it would be definitely better if there are trained judges manning these specialized courts, which would definitely do well insofar as speedy disposal of arbitrations, even during the pendency of arbitration, is concerned. I was doing some study where I came to know that even applications filed under Section 11(6) of the Arbitration Act for appointment of arbitrators have been pending in the high courts for a considerably long period of time. So these matters have to be taken up early to ensure that there is a way forward insofar as the appointment is concerned. Now coming to the international commercial arbitration with which we are really concerned today. Even before the 1996 Act, by a judgment to the Supreme Court in Renu Saga, the Supreme Court was of the opinion that insofar as enforcement of foreign awards are concerned, courts would interfere in matters when there is a challenge to the enforceability only on extraordinary grounds. Public policy, as interpreted in that judgment in 1994, was to the effect that you need something more than a violation of law to oppose implementation or enforcement of a foreign award. There were certain judgments of the Supreme Court which treated Part 2 of the Arbitration Act, which deals with the enforcement of awards, on par with the domestic awards. But we came a full circle, and in the recent past, we have gone back to the Renu Saga times. There is an amendment also that is made to Section 44 to Section 48, where it has been made very clear in the explanation that the enforcement of awards, as and when it is sought for in courts, they should not interfere with matters on merits. The recent trend, as can be seen for the past 5 years to 7 years, you would see that the court has been very supportive of arbitration being a very effective alternate dispute resolution apart from mediation, which not only takes the burden of the courts, which can spend their valuable time in deciding other matters, but also provides an incentive to investors coming to the country and to help businessmen to find a faster way of resolving their disputes. There is so much more to do. There are various topics pertaining to the challenges that are thrown up, mainly having a cost-effective arbitration, a speedy resolution to the disputes, and a host of other issues that arise which can be taken good care of by the speakers that follow. Thank you.
Thank you very much, Justice Rao, and good afternoon, everybody. It's a real pleasure to take part in this event and see such an excellent turnout here in Dubai and all the people joining online. It's really great, I think, to be back to a in-person event once again. We're seeing a little bit more of it all the time. And let's hope we continue. I am going to highlight three challenges that I see in terms of cross-border dispute resolution with a focus on arbitration from my vantage point as an arbitration practitioner here in Dubai. As you'll see, I'll start at sort of a global level and become more Dubai-specific as I go. I think, and I will try to do this all within 10 minutes. I think the first challenge that I see, and this is a challenge that we've already alluded to, the speakers have already alluded to numerous times this morning, and that is the issue of time and cost of arbitration proceedings. When we talk about time and cost of arbitration, though, I think it's important to take a step back and realize that domestic arbitration and international arbitration have slightly different origin stories. Domestic arbitration very much emerged as a faster and cheaper form of dispute resolution vis-a-vis court systems and jurisdictions across the world. International arbitration, on the other hand, I would say arose primarily to find a neutral forum. A party from country A enters into a commercial transaction with a party from country B. Country A party doesn't want to be in the courts of country B, and vice versa. So they've turned to arbitration as an alternative form of dispute resolution for their disputes. Often these commercial transactions, at least historically, have been significant in size. They might involve large infrastructure projects, hundreds of millions of dollars in dispute. And then when we talk about international arbitration, the impact of the New York Convention, the enforceability of those awards. The point being that international arbitration, at least as it developed initially, was not a form of dispute resolution that necessarily had a focus on speed and efficiency. That, of course, is changing as international commerce increases and parties increasingly turn to international arbitration for all types of cross-border disputes, large and small. And so I think it behooves the international arbitration community to be able to cater to all those needs. And even though international arbitration may not have started with a focus on speed and efficiency, it needs the tools in order to do that, to ensure that we have speed and efficiency when the parties need that. And I think we're seeing many tools emerging and being presented in arbitral rules across the world to achieve that. My colleague Ganesh will be talking about one example, emergency arbitrators, later on. I think probably the prime example is the use of expedited procedures in various arbitral rules around the world, most recently in the new DAC rules, which we'll talk about more in a little while. I think another interesting mechanism that we see when we talk about time and cost is the mechanism of early dismissal or summary disposal of claims. This is a mechanism that we see in some domestic court systems that made its way into the ICSID rules at one point. SIAC has it, SEC. We recently saw it in the LCIA rules of 2020 as well. These are early dismissal mechanisms where claims can be dismissed at an early stage of the arbitration that are, and the language varies from rule to rule, but generally speaking are manifestly without legal merit or manifestly without jurisdiction. I think one interesting development when we talk about early dismissal mechanisms here in the region, just down the road in Abu Dhabi, in the amendments to the ADGM regulations. The ADGM is the Abu Dhabi Global Market. It's a financial free zone, similar to the Dubai International Financial Center, that has its own set of commercial laws and its own arbitration law. The arbitration law is known as the ADGM regulations. When those were amended in late 2020, an early dismissal mechanism was incorporated directly into the arbitration law, directly into the ADGM regulations. I think this is an interesting development. It's the first example I'm aware of where an early dismissal mechanism has made its way into an arbitration law rather than in the procedural rules of an arbitral institution. So I think it'll be interesting to see how that develops and how it's implemented in practice. The second challenge that I see from my vantage point here in Dubai, and I am going to get a little more Dubai specific at this stage, is the challenge that I see in relation to the need for specific authority. A signatory to an arbitration agreement must have specific authority or special authority to bind a party to arbitration. This is set forth in Article 4.1 of the UAE Federal Arbitration Law, which came into effect in 2018. And let me make clear, I'm very bullish on the UAE Federal Arbitration Law. I think it's a good law. It's based on the UNCITRAL model law. But I think this requirement for specific authority is one sort of nagging issue that does create some challenges for parties, in some cases in practice, at the set-aside and enforcement stage. I think the UAE courts are trying to develop certain approaches and doctrines to remedy the potentially difficult impact that this requirement for specific authority may have on parties. The UAE courts are adopting certain presumptions in favor of authority. So, for example, one of the presumptions that have been adopted in some cases is that the general manager, there's a presumption that the general manager of a limited liability company does have authority to bind the LLC to arbitration. However, that authority can be altered in the company's articles of association. And so it is important for parties entering into an arbitration agreement with an LLC here in Dubai that they check those articles of authority to ensure that the general manager has the authority to bind the parties. We're seeing other mechanisms, other doctrines adopted by the UAE courts to address this issue of specific authority, doctrine of good faith, estoppel, and others, but it is one that parties do continue to need to be aware of when they're entering into arbitration agreements in Dubai. Let me just briefly say that, when you talk about set-aside and enforcement of awards here in the region, when I talk to lawyers and parties from outside the region, a lingering concern is in relation to public policy. And I have to say that from my vantage point, certainly here in the UAE, public policy is not the issue, is not a challenge, is not a obstacle to the enforcement of arbitral awards that many think it may be. And I think the same thing is true in Saudi Arabia as well. The Saudi Center for Commercial Arbitration did an excellent presentation during Dubai Arbitration Week where they revealed the results of a study they did involving over 500 Saudi court judgments relating to arbitration. 107 of those judgments related to set-aside applications, and they showed that just in only 6% of those cases was a set-aside application granted, and only in 3% of the cases did it relate to issues of public policy or Sharia. So we, I think, are trending in a very positive direction here in the region when it comes to public policy and the impact on arbitral awards. I'm quickly coming up on my 10 minutes, so I want to turn briefly to the third challenge that I see. And I think it's important to remember that challenges often present opportunities, and I think this is very much the case in what I'm about to address. But probably the most recent challenge that we've seen here in Dubai in relation to international arbitration is the recent passage of Decree number 34 of 2021, which effectively, and I'm simplifying matters just a bit, but Decree number 34 effectively consolidated the DIFCL-CIA Arbitration Center and the Emirates Maritime Arbitration Center into DIAC, the Dubai International Arbitration Center. The decree provided for a 6-month transition period for that to take place, and that has effectively been the last 6 months. If I'm not mistaken, the transition period ends on Monday or Tuesday, and I think to a very great extent, some of the challenges and uncertainty that we've seen over the last 6 months have cleared. And the reason they have cleared is that DIAC has issued a new set of arbitration rules in the last couple of weeks, which come into effect on Monday, again, if I'm not mistaken. And based on an initial review of these rules, I'm very optimistic, very bullish about DIAC arbitration going forward. I think it's an excellent set of rules, state of the art. It incorporates, as Mr. Kaitan said earlier, incorporates many of the key provisions that one expects to see in a modern set of rules. I could go on, but I'm going to stop there because shortly we will be hearing from the registrar of DIAC, who is eminently more qualified than I am to comment on the DIAC rules. But let me just say from a practitioner's perspective, we really do like what we're seeing. So those are my 3 challenges. Thank you very much for the opportunity to speak, and I look forward to the rest of the conference. Thank you.
Thank you, Justice Rao, for the kind introduction. Justice Kohli and all senior counsel from India and senior lawyers from UAE and dear friends, Mr. Kaitan, Mr. Chawla, congratulations to ICA on the 4th edition, that too outside India, this beautiful city of Dubai. I think the chiefs mentioned about institutional arbitration. I think ICA has done an excellent job as an institution. And I would like to actually start because Tom was mentioning about the challenges on time and cost. And before I go into my topic proper, I thought I'll start with an anecdote because from morning we have been listening to a lot of serious issues of law, and I thought because lawyers like to joke about themselves, So there was this client who went to a lawyer, and he entered his office, and it was a very swanky office with all glass rooms, and so he was like perturbed. And the first question he asked the senior lawyer is, listen to me carefully, the first question he asked the senior lawyer was, what is his fees? The lawyer said, $500 for 3 questions. And the prospective client said, isn't that too expensive? The lawyer said, yes, it might be. Anyway, what's your 3rd question? So I think this is something which weighs in the mind of clients, especially for us from law firms. I mean, there are several colleagues from other firms as well. I think clients are very, very conscious about cost and time. Of course, in India, we've now amended the Arbitration Act for the award to be made within 12 months from the time the pleadings are closed. So it's very, very important, and one of the major contributors to keeping the costs reasonable is institutional arbitration. And what I would like to focus today is on the challenge relating to interim measures of protection. Can I please have the slides on? Thank you. This is what I propose to cover, interim measures of protection in general and specifically on emergency arbitrator. As there's some interesting development in India in a recent case which has been covered in the legal news, not just in India but worldwide. I'll of course not go into the nitty-gritties of that because we have one of the authors of the recent judgment sitting here, and the Chief Justice and Justice Kohli were part of the bench. Interim measures essentially in cross-border dispute resolution is, of course, the challenge is about enforcement. And I'll cover this aspect when I cover the emergency arbitrator provisions. But before that, can a domestic or a national court grant interim relief in aid of foreign-seated arbitration? That's something which is very important, because if you have an arbitration, let's say in a foreign country, and you're, let's say in London, and you have assets of one of the parties in India, can the Indian courts grant interim relief? Because even if you succeed in the arbitration, if the assets of the parties are siphoned off before you can enforce the award, it's just going to be a paper award. So it's very important for you to get an interim measure of protection so that this is not dissipated, for example. So can a court grant such measures? I mean, I'm just giving you the example of India, but across the world, is it possible? This would depend upon whether the legislation, the lex arbitri, that the law governing the arbitration, provides for such a power to the courts in the place where you want to go and get the interim relief. And it also depends, if you don't have it in legislation, whether any case law or precedent supports this. Of course, in civil law countries, there's no doctrine of stare decisis that will apply, but in common law countries, and here we are though we are in Dubai, it's almost like an Indian city, as somebody said. So we are talking about common law countries. If there are decisions, yes, of course, you can support that. Indian courts, by the way, it's now very clear that Indian courts can grant interim relief. A little bit of background, there was a case of Bhatia International in 2002, where the Supreme Court of India held that Part 1 of the Act contains most of the provisions, and the second part relates to New York Convention enforcement of foreign awards, and then we have a part on conciliation. So it has a provision under Section 9 for the courts to grant interim measures of protection, but the court said that Part 1 would apply to arbitration seated outside India unless you expressly say that it would not. So the court said, yes, we can grant interim measure of protection. But in India, the lawyers are very innovative. So they used the ratio in Bhatia International, in another case called Venture Global and Satyam, where they said under Part 1, you have Section 34, which is a set-aside provision, where you can file an application to set aside an award. And they said even if the seat is outside India, a foreign award, you can still file an application in India because the entire Part 1 applies extraterritorially. So when this judgment came out, there was a huge hue and cry in the international arbitration community. At the time, I was practicing in Singapore, and I remember there were so many articles written by a lot of international law firms. And then you had the other extreme in Balco, which said Part 1 will not apply at all to foreign-seated arbitration, while Balco was a step in the right direction because, it did not allow courts to interfere or grant under Part 1. It would have posed a problem because how do you now go to the Indian courts to get an interim measure? But all this has now been put to rest. In 2015, the Arbitration Conciliation Act in India has been amended, and Section 2.2 expressly states that Section 9 will apply extraterritorially. So even if you have a foreign-seated arbitration, you could go to the Indian court and apply for an interim relief, and if the court considers it appropriate, there are chances that you might get that relief. Position in Singapore, very quickly. In Singapore, you had a case of Swiss Fortune, where the court said, this was in 2007, the Court of Appeal, which is the highest court in Singapore, said there is no express provision in the International Arbitration Act for the courts to grant interim measures in favor of a foreign-seated arbitration. Quickly, the act was amended by the parliament, and now a new Section 12A of the act, which was introduced a year or two later after the judgment, which in effect provides that irrespective of the seat, the court can consider applications for interim measure. Emergency arbitrator is what I want to deal with next. In fact, Justice Rao was mentioning about that as well in his introductory remarks, and Tom was alluding to some of the institutions that have these provisions in their rules. It's essentially for those, I know it's a mix of lawyers from arbitration and the commercial world, so for those who may be hearing this for the first time, it is nothing but emergency arbitrator is a neutral person who is appointed prior to the constitution of the main tribunal, he or she deals with emergency interim applications. So some of the institutions, in fact, it was first started by the AAA, American Arbitration Association's international arm, the ICDR, And then SIAC followed suit, and many other institutions have it. Our Indian Council of Arbitration has it in its rules as well, and several other institutions in India also have it. So what is this? I'll take the example of SIAC because SIAC has been very popular with Indian parties. I know DIAC is also coming up with this provision effective Monday, but I'll take SIAC as an example because Indian parties have been using that a lot. And before I move to that, I also should mention about the recommendation made by the Law Commission in its report where they had proposed that the term arbitral tribunal should include emergency arbitrators where rules of institution provide for such emergency arbitrator provisions. But in the 2015, we did not adopt it. And Justice Sri Krishna had proposed it in his report as well. And again, in 2019, we did not adopt it as well. But that said, the Supreme Court has recognized that this is enforceable under our section 17(2), which is essentially provides that any interim relief granted by an arbitral tribunal can be enforced like an order of court in a decision which I'll be coming to in a couple of minutes. The SIAC rules provides for emergency arbitrator. I'll just go through it very quickly because of reasons of time. Essentially, you can get an emergency arbitrator within 1 day. Earlier, it was 1 business day, but now you could get it an arbitrator within 1 day. And within 2 days, as opposed to 2 business days, you can, it has to be, the proceedings will start and schedule will be conducted, and within 14 days you can get a decision. So that's what the SIAC rules provide for. And we'll see some, kind of case studies, I think I jumped a few slides, just a minute, yeah. And, the Singapore International Arbitration Act, I just want to give you an example. There, the act was amended to include the definition in the arbitral tribunal to encompass emergency arbitrator. So now that's very clear in Singapore. I hope now that the Supreme Court has recognized in the next round of amendments, we hopefully will do that in our law as well. In the Indian context, I just want to tell you that India, traditionally parties have been using this provision a lot, perhaps because we tend to go to the court to get a Section 9 order. That's always been the case with Indian parties. And when this rule came up in 2010, I think the first ever case to invoke the provisions in SIAC was 2 Indian parties. They went to SIAC for an emergency interim relief, and they got a decision very, very quickly. And in the second case also involved an Indian party, and they got an arbitrator within almost a day or 2, and the relief was granted. But what is the actual problem with this? You get an emergency arbitrator order or an award, let's say in Singapore or London or wherever. How are you going to enforce it in India against the Indian party? So what's happened is the Indian courts have been very innovative. What they've done is any applications filed under Section 9 of the Act, which empowers the court to grant interim measures, and you go and produce this emergency arbitrator decision. In almost all the cases, the courts have they've looked at it, but they've made an order under Section 9, of course, considering the emergency arbitrator's decision as well. So I've just put up a few cases. This was HSBC Holdings, the Bombay High Court. Then Raffles Design, the Delhi High Court expressly said that recourse to Section 9 of the Act is not available for the purpose of enforcing the orders of the tribunal. But that does not mean that the court cannot independently apply its mind and grant relief in cases where it is warranted. So this was hitherto the case when the seat of arbitration was outside India. I'll not go into the Zeech's case about Hotel Mumbai, which was about the attacks in the Taj Hotel in Bombay. There was a movie, and there was an issue there on whether the OTP, over the top, telecast can happen. The Bombay High Court granted interim measures in terms of the SIAC order. I'll quickly move on to the hot topic very quickly for a minute or 2 on the Amazon and Future case. I won't go into too much of details because it's still sub judice and the matter is posted on 1st of April, and I have a judge who's here before me and not go, except that I'll go into the details which are already in the public domain. There was this deal that was supposed to happen between Reliance Retail announced that it had entered into a deal for acquisition of assets and business of future retails for approximately 24,000 and odd crores. That's quite a lot of money. Amazon approached SIAC over its dispute with Future Coupons, which is one of the holding companies of the Future Group, where Amazon had invested about 1,400 crores. Amazon alleged that the transaction was violative of the shareholders' agreement. The promoters of the Future Group, it cited breach of the terms and the sale of real estate of Reliance. It requested an emergency arbitrator hearing. But in this case, the interesting point to note that the seat of arbitration was in India. It was in Delhi. So that's the difference, and that's why the parties, they could approach the courts easily, and our Indian courts were very active, and an emergency arbitrator decision was given. Then, one of the parties went to the Delhi High Court, stayed where the single judge kind of upheld the emergency arbitrator award against Future. Then it went before a division bench, which is a two-judge bench, which stayed the single judge's order. And then the other party approached the Supreme Court against the Delhi High Court order in April of last year, which stayed the single judge's order. So the Supreme Court ruled in favor of Amazon, holding that the SIAC emergency arbitrator decision against Future is enforceable in India. So this is the decision I was talking about earlier. So the court expressly said that under our section 17(2), which was amended in 2015, an emergency arbitrator's decision can be enforced like an order of court, at least where the seat of arbitration is in India. So what the point here I'm trying to make is, if the seat is outside India, then you have no choice but to come under section 9, or you go to Singapore courts, you go get an order in terms of the order, but that's going to be very complicated. So section 9 is the way forward. So this is a major challenge. And in this case, this for completion, the matter is sub judice. Then there was another round where the main tribunal was appointed in that case, and the main tribunal upheld the emergency arbitrator's decision, and against which there have been appeals, and it is right now pending before the court. Parties tried to settle. They just represented to the court a few days back that the initial, the attempt to settle did not work, and now the other side has been given time to file its reply in an interlocutory application filed by Amazon. And the matter is now posted for 1st of April. So this is some space that we want to watch. So these were two aspects I wanted to mention, generally about interim measures and about emergency arbitrator. I think it's an amazing kind of weapon in the armory of dispute lawyers, because this is something which is very creative, it's new, and it's in vogue everywhere, and even Indian institutions are kind of adopting it. So I think and hope that a legislative amendment will take place recognizing the emergency arbitrator in India in due course. With that, I really thank ICA for the opportunity. Thank you very much.
Good afternoon, ladies and gentlemen. I hope you'll allow me to stand on the preceding protocols of welcome, even time constraints are tight. Thank you to the ICA and to Vicky for the invitation, and to all of those working behind the scenes to make this happen. It is an honor to speak in your company, amongst you speakers, and of course, under your excellent chairmanship, Justice Rao. Time is not with me. Buildings go up in Dubai with alarming speed, so forgive me for embodying that principle today as I move through my topic with some haste. The link between arbitration and globalization is perhaps indisputable. Indeed, it is the theme of our conference today. With globalization comes an increase in cross-border commercial relations, typically recorded by way of contractual arrangement. That in turn produces cross-border disputes of often a complex contractual nature, and that in turn fuels arbitration. Its modular nature and inherent flexibility is suited to differing scenarios, and there are various aspects of its being which are seen as perceived advantages. So that thesis is generally accepted. There is a relationship between the two, but so it must follow that arbitration has to respond to the challenges facing globalization as well. It is a service. It has to adapt. It has to evolve. Arbitration is nothing without its users. So Tom and Ganesh have expertly identified and illustrated some of the challenges that face arbitration today. I hope you will forgive me. I will take a slightly different approach. I've dusted off my crystal ball, and I'm going to look forward. I'm going to raise a couple of issues which I believe may be challenges in the future. I may be wrong. If you speak to my wife, she will tell you I'm regularly wrong. But let us see where we get to. There are three buzzwords that face or that are raised in the context of challenges to globalization. They are the following: climate change, sustainability, and regionalization. Now, pausing there, a number of you, in fact, many of you, perhaps all of you, may reflect and go, what on earth does that have to do with arbitration? Hopefully you will see the theme that I'm trying to run through in my presentation. It's not necessarily about the content of those three issues, it's more the message that pervades underneath. So let us turn to the first, climate change disputes. They are on the rise, so we are told. A report by the London School of Economics, published in 2021, so last year, examined figures from 40 countries, 13 international and regional courts or tribunals. For the 28-year period between 1986 and 2014, they identified 834 climate-related cases. That's about 30 per year. The Paris Agreement was signed in 2015, and from 2015 to 2021, a much shorter period, over 1,000 cases were identified, about an average of 170 cases per year. Now, those cases were predominantly against governments, brought by NGOs, individuals, corporations. And so it might rightly be thought, well, what does that have to do with international commercial arbitration, which is typically a business-to-business or commercial-to-commercial method of dispute resolution? But we might be at a tipping point. In May of last year, a district court in the Netherlands privatized climate change concerns. It ordered Shell to reduce its global CO2 emissions by 45% by 2030 on the basis of a tortious duty of care under Dutch law. Not a convention, not a bilateral investment treaty, but a local provision of tortious law. Indeed, we're seeing greater pressure from stakeholders, shareholders, investors applied to corporations to adopt policies and conduct business in a more ESG or socially conscious fashion. So how is that going to manifest itself in arbitration? Well, we're probably going to see the imposition of contractual obligations, standards within supply chains, obligations to source materials from certain ethically approved sources, sustainable activities. And so with that, we will see allegations of breach. And those allegations may well find themselves in private commercial arbitration before constituted tribunals. And that presents a number of challenges, I would suggest. These obligations will be endeavors obligations. They won't be absolute. They will require best efforts, reasonable efforts. What will be the standards? What will be the benchmarks? How will you know if a breach has occurred? That will be left to private tribunals to determine. Will certain laws be more or less advantageous? Will the courts of certain seats seek to intervene on public policy grounds if awards are brought before them? Will there be a specialist bar? Will there be specialist experts? Will there be institutions who come to the fore in being conscious climate change, ESG-related matters? And of course, there's the enduring issue of private tribunals in confidential proceedings determining issues of potentially public importance, which deprive, some would say, the common law of value because precedent is not established. And certain sectors, I suspect, will be impacted first: construction, oil and gas, manufacturing, which have cross-border supply chains. And it is perhaps known well to you all that those sectors are the heaviest users of arbitration at the moment. I move on to my second issue, sustainability. I will deal with my next two more briefly. You'll be perhaps delighted to hear. The issue of sustainability in the context of arbitration is viewed through the prism of green arbitration. COVID-19 has perhaps accelerated the transition and focused minds. We have virtual hearings, which eliminated travel. We have virtual bundles, hearing bundles, which eliminated paper. We have remote working, which imposed new ways of practicing arbitration and led to a huge investment into IT and innovation within legal technologies and services. And now, frankly, the framework needs to catch up. Arbitration laws are being updated. For example, how does a virtual hearing sit with basic access to justice and fairness norms? That is a question which everyone is debating. Do institutional rules need to be updated? Does guidance need to be issued? Do we need protocols to reflect the new ways of working so that minimum expectations are met? Now, some might say that arbitration, with its inherent flexibility, is better placed to meet such sustainability goals as I've defined them, or at least commented on them a moment ago. Perhaps, but I think we've seen national courts in many jurisdictions leading the way in reacting to COVID-19, imposing remote hearings, imposing guidance. Indeed, in my own jurisdiction, my national courts moved a lot quicker than most of the arbitral institutions in which I plow my own business. And then, of course, is this an opportunity for disruption? Will the existing arbitration players rest on their laurels? Will new institutions be able to come to the fore, to not think, where do I need to be now, but where should I be tomorrow? Finally, regionalization or nationalism. The basic minimum expectations, protections, and requirements of international arbitration are well known. We've heard many of them today. Indeed, the Honorable Chief Justice himself set out 14 requirements he would like to see arbitration in India to adopt. There is a baseline model which is generally accepted in the international community. Indeed, there is a model law. Now, I raise the two previous issues because it perhaps illustrates the maturity of the debate around international arbitration in certain sectors. Climate change and sustainability are not legal issues. They're socio-political issues, but they find themselves inevitably leaking into the dispute resolution process, which is international in nature. Now, there may not be a consensus on climate change and sustainability, and I fully acknowledge that it might be strange to bring up such issues here, and I fully acknowledge that I speak through prisms of perhaps an Anglo, Euro, indeed Western viewpoint, and that's fine. The message is more what underlines what I've raised today, which is, as the practice of international arbitration matures, we may see diverging approaches appear. And with that, there are challenges, but of course, there are opportunities too. Indulge me for one quick moment and let me give you an example. Alongside the growth in arbitration cases, which all of the institutions will show you via the data published on an annual basis, we have seen a shift in the preferred seats. In the Queen Mary, in the Queen Mary survey of 2015, London and Paris were the most favored seats by quite some margin. But by 2021, the same survey found that Singapore and Hong Kong had overtaken Paris, and that in fact Singapore was tied first with London. That's in 6 years. We've also seen the growth in the number of seats and the number of arbitration centers. A report in 2020 identified nearly 100 institutions in Africa, and we have heard commentary today as to the number of institutions in India. And the data, if you take a step back, suggests that there is in fact an elasticity between the location of an institution and a seat and its users. It's no surprise to hear Ganesh say that Indian parties, and in fact Asian parties more generally, tend to use SIAC. It's perhaps no surprise that Miami is the favored seat for Latin American arbitration. Perhaps it's no surprise that the ICC is used in FIDIC standard form contracts. And so it stands to reason that perhaps as the user base grows, the practice of arbitration, and once the practice of arbitration meets the basic model standards that we all accept in each region, regionalized arbitration will follow. And so I pose these questions for your thoughts. What challenges does that regionalization present to the existing players in the market? What opportunities does that present to the newer players? And how has COVID-19 acted as potentially a platform for disruption? Of course, for the newer players, don't run before you can walk. The standards and expectations I've referred to must be there. There needs to be confidence in the system. But, question, where should you be? We speak a lot about where newer arbitration hubs feel they need to be, but perhaps the question you should be asking yourself is, where do you wish to go? And I think the fact that we are having this conference hosted by the ICA, with Ficky's support, in Dubai, presided by the Honourable Chief Justice and a number of justices of the Supreme Court, and with a diverse range of speakers, bodes very well, I think, for the future of Indian arbitration. Thank you.
Good afternoon. I hope everyone can hear me well. First of all, I would like to thank you for having me today, and it is an honor to share this stage with such esteemed panelists and to be able to present today in front of such esteemed audience. What I can say, my fellow panelists, seasoned practitioners have covered to a profound extent the challenges that occur in cross-border disputes from the perspective of their private practice. And I would like in turn to focus on those challenges from the perspective of international arbitral institution and share with you some insights how these challenges are seen from our perspective and are dealt with. My main focus will fall today on time and cost challenges, which Tom has mentioned and clearly covered in his first 10-minute speech. And it might look very basic in the beginning, but I would like to focus on some points which, to a certain extent, appear irrelevant initially, but tends to be so commanding when the dispute arises. Before my career with DIAC, I was practicing as in-house lawyer, I was also practicing within a law firm as a counsel and partner, and I was not able to imagine how creative the parties sometimes may be in the wording of their arbitration clauses, particularly with focus on selecting someone credible to nominate or appoint an arbitrator on their behalf. We come across even the cases where the parties requested that the sheikh would appoint an arbitrator for them. And why I'm bringing this up, because this is not the case of 5% or 10% even within all the arbitrations which we come across. It comes to 20 and 30% of the cases, which from the view of institution is a huge share. And I may say that, like most institutions, of course, we are aimed to honor the parties' freedom and choice to the greatest extent possible. Still, all this ultimately eventuates in unnecessary procrastination with no much advantage for the party at the end. While the parties might consciously believe in the beginning that they would benefit from such a unique appointment process, this is a mere illusion. No one better than a professional legal counsel or designated for this purpose institutional body is equipped to serve this purpose. So the advice would always be to keep it straightforward and stick to standard arbitration clauses which are available and which are provided by different arbitration institutions. This would save the parties time and costs. As an example, in our practice, we had a case which referred to the appointment of the tribunal to the body within the DIAC, but which was erroneously named and vacant at that time. The DIAC executive body has rightly classified this part of arbitration agreement as inoperative and proceeded with direct appointment. However, the respondent party, losing party ultimately, did not miss the chance to use this for introducing continuous challenges and parallel court proceedings. Worth it to note that the dispute itself was not that intricate, but due to the selected inoperative appointment mechanism, the case lasted for 6 years. And of course, it affects the cost efficiency in arbitration, and in all such cases where the arbitration clauses were not drafted thoughtfully, the lion's share of the cost were not the fees of the tribunal and institution, but the legal fees that doubled and sometimes tripled the cost, because as you can imagine, the parties had far more than 3 questions which Ganesh clients asked about. And I would like also to turn to focus on the challenges from the, sorry, this is the wrong paper. Another thing which I would like also to focus on is a choice between institutional and ad hoc arbitration. Should the parties wish to resolve their dispute through ad hoc arbitration, they should appreciate from the very beginning high probability of another party non-participating in the appointment process, which ultimately would require the party who initiate the arbitration to seek the involvement of either of the appointing authority agreed in the beginning or the applicable court forum. This, of course, increases time, increases cost, and if the proper legal advice would be sought in advance, it could be easily avoided. For example, the practice now dictates that if the ad hoc arbitration seated in Dubai requires an appointment, a default appointment of the arbitrator, the party seeking it from the Dubai courts eventually ends up with Dubai International Arbitration Center, because the recent practice of the Dubai courts is to refer all such applications directly to our institution, who is more specialized on selecting the qualified and suitable candidates for addressing the dispute of the parties. It might also not be so straightforward with the choice of institution, because we've observed lots of cases when the parties, without any order of preference in their agreement, agree on 2 or 3 alternative institutions, when the selected rules and designated arbitral institutions are different, and thus we reach the deadlock, when the designated institution doesn't exist itself. So, without saying all this derail the arbitration proceedings and increase the costs. That is why a dispute lawyer engagement is so crucial in the beginning stage in drafting of the arbitration clause. Having said this, it brings me to another topic, which regarding the Decree 34, which Tom have alluded to previously. And I will not go much into further details of this decree. The introduction has been already made. According to this decree, the new entity, the new Dubai International Arbitration Center appeared, completely independent financially and administratively from the Dubai Chamber of Commerce and Industry, which was initially the initiative of the Dubai Chamber. Moreover, into Dubai International Arbitration Center, 2 additional arbitration centers have been merged. Maritime Arbitration Center, and DFC Arbitration Institute. It is important to say, of course, it was a challenging period for all stakeholders and for the arbitration community in the region. And I would like to say here that, to use the Albert Einstein saying that in the middle of every difficulty, there is always lies opportunity. And this brings me to the point where I can gladly conclude that starting 21st March, which is the end of transitional period, the DIAC will be registering all new cases with referrals to the abolished arbitration centers. And as fairly mentioned by Ms. Gita, Vice President of ICA, behind the party's choice of institution lies the rules of arbitration. The DIAC will apply to all newly registered cases the new recently adopted DIAC Rules 2022, which have been crafted to address all the challenges which the speakers have been covering today. If the time allows, I would focus and give brief overview of the most significant changes in the rules. It is important to mention that the seat of arbitration has been changed. The seat of arbitration now, as the default seat of the arbitration, would be Dubai International Dubai International Financial Center, which means that the common law will be possible to apply to the arbitration seated in the DFC, where the agreement to arbitrate indicates a location or venue of arbitration. And unless the parties agree otherwise, the DIAC also clarifies in its rules that location or venue shall be deemed to be a legal seat. We also introduce exceptional procedures, which includes the tribunal's power to order interim measures and a new emergency arbitrator procedure. So I received a message that we are running out of time. The rules, just to finalize, that the rules have a lot of novels, such as emergency arbitrator, tribunal's powers to rein in disruptive conduct of the parties, and to sum it up, the rules focus on fairness and efficiency core objective, and are suited to fit both complex construction and engineering disputes, as well as low-value, straightforward claims. Thank you for your attention.
It's quite difficult to stop speakers, especially when they are speaking at full flow and then sharing their ideas. We are behind the schedule by about 40 minutes. You have a long day to go, 3 more sessions. This might even cut into your lunchtime. Though we can't take too many questions, but we will still take a few questions. The panelists are here to clear your doubts or even take any comments. So we'll take a few questions.
I think the audience knows lunch is around the corner.
Yes,
very
yes,
smart.
Yes, it is. So I thank the speakers along with the others. I have been benefited by your thoughts. We have learned so much. And I thank all of you for the rapt attention and for your time. Thank you very much.
Okay, so we will now break for lunch, but we will come back to a very interesting session sharp at 2:40 p.m. as the Honorable Chair of the session is joining virtually from India, hence our request that we stick to our time, please. Thank you. Not good.
I've been fucking hoes and popping pills, man, I feel it's like a rock star. All my brothers got that gas and they always be smoking like a rock star. Fucking with me, call up on a OC and show up, man, then they shut down. When my homies pull up on your block, they make that thing go grata-ta-ta. I've been fucking hoes and popping pills, man, I feel it's like a rock star. I've been fucking hoes and popping pills, man, I feel it's like a rock star. All my brothers got that gas and they always be smoking like a rock star. Fucking with me, call up on the OC and show up, and then they shut down. When my homies pull up on your block, they make that thing go grata-ta-ta. Switch my weekend back in black and started saying rest in peace to Bon Scott. Said that we blowin' smoke, she hits me light a fire like a North Sun. The full stage, probably leave a fucking show in a cop car. She was legendary through a TV out the window of the montage. Cooking on the table like a party, don't give a damn. Dude, your girlfriend is a rookie, she just tryna get in. Singing on with the band. Hey, hey. Now she acting out of pocket, try to grab her from my pants. I'm in bitches in my trailer, say she ain't got a man. I'm the hero of the band. niggas and they always be smoking like I'm about to stop. Fucking with me, call up on the OC and show up and then they shocked up. When my homies pull up on your block, they make that thing go ta-ta-ta-ta.
Testing Zoom live. Check, test. Test Zoom live. Anyone live on Zoom? This is the actual link. Test. Test. Check. Yeah, let us. No, because no one is speaking here. No, that I need to get from the platform.
Hello, can you hear me?
What is the audio level?
Hello?
Sir?
Yeah, actually your voice is low.
Audio level? Test. Hello? Somebody can reply from Zoom. Do you hear us clearly?
Yes, yes, now it's
But
clear.
their level is very low. Yeah. Full. I opened the video. No, so touch. No speaker icon there. Preferences. No, not in Zoom. Settings. Show in the menu bar, it's there. When active. Stamp on me. Send me. I think this is not host. Yeah, which one is the host? He only owns it. You should keep the this one, right? Can you
He's online. And what about Lydia? Is she online? One second, but is Lydia online? Is Lydia online? Uh, Vicky is not Lydia.
Dr. Chandrachud online.
How? No, but how will he come to the platform? So should yes, I'm part of that. I'll come. Who's the host?
But you can speak to
Are but start.
You can, Lydia has come. Yeah, she has come. She has
Okay.
come. That's Lydia. You can speak to them through this phone. No, they're on mic. Put them on the screen with the split. See, Kumandal want to come. Tell them to open the videos.
Lydia and Dr. Chandrachud, please can you come online with your videos in a minute? Thank you.
Only you. Total. Say, which one I have to hide it here? Only these two. No, pin three of them. Hide all. So that is what you pin them. Now she wants to dump it. You don't need this one? No. There, there. This one pin. This one. Pin. Okay. Chandrachud also pin. That one is pin. कौन सा नंबर क्या नंबर में देखना पड़ेगा हमारा गाड़ी और किधर पार्क करके जाना था Now you put show all marks. No, don't replace it. Ah, we are on. Sorry. You can put gallery. Gallery, but they have to open the video. Yes, come. Okay, keep this one. So it is this one. This one is now. You can do it now. No. Stop. No. Float? No. Make a floating. Hide selfie, right? Okay. Show this one.
3671.
That's ISC. Avatar.
Then park your car and remove it from there.
Wait, I don't know. The problem is the driver took the key and went to Abu Dhabi. That is the issue. Let me see.
That's a
One
delivery
second,
area,
I'll find out. Zoom platform, can you please confirm that you hear us and you speak also that we can hear you as well? Do you hear us?
Hello from London.
Okay.
Yes, we can hear you.
Confirm, thank you. What you're showing them now? Can this one go to the screen? Yes. Aloy?
watching.
And we are just putting on.
Ladies and gentlemen, we are going to start with this session, and all the panelists are online, including the chair. May we request you to take your seats? Yes, ladies and gentlemen, we know the session after lunch is often a dreaded session as it forces you to keep awake. So we have made sure that you have a pulsating session soon after lunch on a topic which has justifiably caught the attention of the global community: navigating artificial intelligence and technology disputes via arbitration. In a world where the growth of technology is exponential and legal systems have to periodically play to catch up, the topic for today's session becomes a crucial point of discussion for all practitioners. We are fortunate to have a panel of high-profile experts in this session, chaired by Honorable Dr. Justice D.Y. Chandrachud, Judge, Supreme Court of India, who has joined us virtually. Justice Chandrachud, we appreciate that on account of your personal contingencies, you were unable to come physically. Ladies and gentlemen, any introduction to Justice Chandrachud is needless, as he is well known and revered by all stakeholders. His charisma, both on and off the bench, has generated much fandom. Someone who hails from a family which has given 2 Chief Justices to our country, Justice Chandrachud's vision not only extends to the landmark judgments he has delivered, but also in the area of judicial reform, judicial education, legal aid and services, advancement of alternate dispute mechanism, particularly arbitration and mediation. His tech-savvy attitude and passion for technology make him the ideal judge to lead the E-Committee of the Supreme Court. We are looking forward to hearing his expert views. So, ladies and gentlemen, please welcome Justice Chandrachud once again, along with his panel of senior arbitrators. Before we hand over the session to him, we will present him with a green certificate in a virtual manner, and which we will, Justice Chandrachud, I promise you that I will have it delivered physically when I'm back to New Delhi. This is a pledge by FICCI and ICA to plant 6 trees in your name on the outskirts of Sundarbans National Park. This is FICCI's ecological way of honoring the guests. So thank you very much once again for joining online. In spite of your so many constraints and precious time, I welcome you once more. May I request you to deliver your keynote address and lead the seminar thereafter. Thank you.
Thank you very much for the very kind words. Thank you very much to P and to ICA for inviting me this afternoon. We are using a technological platform to communicate from between London and India and Dubai. It's become par for the course now. It would have been quite a revelation several years ago, but that's how the Supreme Court of India conducted its hearings during the course of the pandemic. So we were able to sustain access to justice thanks to technology. So it's a matter of pride for me to disclose this and share this with you as I share some of my thoughts this afternoon. Well, technology and arbitration are so intertwined in the pursuit of justice that it is impossible to discuss either of these concepts without referring to the other. While technology expands the realm of arbitration, making it more cost-effective and efficient, arbitration is entrenching as the best dispute resolution mechanism for issues involving the complex interplay of law and technology. Artificial intelligence and technology are slowly penetrating various walks of life. Robot-driven cars, robot helpers, and robot adjudicators are considered essential in this modern, fast-paced world. However, the technological advancements are not accompanied by the development in the legal framework. This eventually leads to a situation where issues relating to technology law become non-adjudicatory, as there is a lack of a legal framework governing the field, a unified legal framework governing the field. For example, a plea seeking damages against an accident caused by a robot-driven car cannot be adjudicated unless the issues of personhood and accountability of artificial intelligence are settled. Technology and artificial intelligence are integrated into commercial transactions. One such example of integration of technology and contracts is a smart contract, where the terms and conditions of the contract are encoded. A breach in the terms of the contract would automatically enforce the contract. For example, if there is a clause in a contract which stipulates that the payment for rented articles must be made on the 7th of every month, then a non-payment of the rent within the stipulated time would automatically enforce the penalty clause. One illustration of smart contracts in the insurance sector is providing travel insurance through a smart contract so that when the transport is delayed, the compensation for the delay is automatically credited to the account of the insurer. The decentralized nature of smart contracts makes it increasingly difficult to identify the place of performance and obligation. Therefore, arbitration is a well-suited method of dispute resolution for transactions encoded as smart contracts. The detachment of arbitration from national jurisdictions, the ability to offer specialized arbitrators who are well versed with the cutting edge technology, and our panel today is really a symbol of that, and evidentiary flexibility are some of the advantages that arbitration as a mechanism of dispute resolution holds over the traditional court system in the adjudication of technological issues. Since disruption in commercial transactions for a few hours can cause substantial financial damage, the key to deciding the appropriate mechanism of dispute resolution is the expedition of solving disputes and providing interim reliefs. Technological disputes involve confidential data and carry enormous financial implications, making arbitration a well-suited choice of dispute resolution. The adjudication of technology and artificial intelligence disputes can be classified into two kinds. First, non-arbitrable issues that are incapable of settlement of arbitration, which involve public rights and third-party interests such as privacy, data confidentiality, personhood, and accountability. And second, arbitrable issues which involve the resolution of disputes such as technological contract infringement. However, all arbitral issues are not necessarily desired to be arbitrable. Absence of delay and cost efficiency are the two most important features of arbitration that further accessibility. Although in practice, neither is arbitration affordable, nor for that matter is it always time efficient. It has been found that arbitration is more expensive than litigation in many contractual disputes. There are also arguments that arbitration agreements might not comply with the requirements of the rule of law, as confidentiality is antithetical to transparency and accountability, and the party appointment of arbitrators is hostile to independence. The arguments against rule of law, coupled with non-accessibility, would then perhaps make arbitration seem to be a less desirable option. Therefore, it is imperative that the principles governing arbitration evolve to stand the test of time and not be drawn into the trenches of the litigation system. Legal professionals from across the globe are also suggesting the implementation of smart contract arbitration, where dispute resolution takes place electronically on the blockchain The arbitration clause is coded into a smart contract where the arbitrator would be the algorithm itself. The UK Jurisdiction Task Force recently published the Digital Dispute Resolution Rules, which provide a procedural framework to resolve disputes arising out of high-tech digital technologies such as crypto assets and cryptocurrency, smart contracts, blockchain, and fintech applications. The rules provide three methods of dispute resolution. First, through automatic dispute resolution, by which the dispute is automatically resolved by the automatic selection of a person, panel, or artificial intelligence agent whose decision would be directly enforced. Second, by arbitration. And third, by expert determination of the dispute. Unlike the traditional arbitration setup, where the parties choose the members constituting the arbitration tribunal, in automatic dispute resolution, the arbitrators are appointed based on preferences of the number, identity, and qualifications indicated by the parties. Since traditional arbitration is slowly but steadily starting to resemble the traditional court system, given the high cost and time consumption in the settlement of disputes, smart contract arbitration seems to be an effective alternative. However, algorithms, as we know, are not free of bias. Prominent artificial intelligence researchers have written that the facial recognition software is less accurate at identifying women and people of color because the software has predominantly been provided pictures of white men. Similar concerns have also been raised in language algorithms, where racist and sexist language is used as the training data. This inherent bias in the algorithm would manifest as various forms of discrimination against the consenting parties. The inclusion of arbitration clauses in smart contracts should not be made a default option. Rather, it must depend on the plausible issues that could arise from the breach of the smart contract. For example, in accident cases, algorithms can be used to compute the compensation that is to be paid by the employer under the formula provided in the Workmen's Compensation Act of 1923 in India. However, the role of the judge in determining if the accident occurred out of or in the course of employment cannot be substituted with artificial intelligence. As Heraclitus, a Greek philosopher, said, "Change is the only constant in life." Technology is transforming the practice of law at an incredible rate. If appropriately used, technology and arbitration can be uniquely intertwined to deliver justice. Arbitration specialists must utilize the new technological advancements to supplement the efforts of the justice system to reduce pendency, also providing their clients with a confidential and efficient system of adjudication. I don't want to take more of your time this afternoon, and we have a distinguished panel of participants and panelists. So I conclude here. And with this, may I now request Mr. Anand Chaudhar. He's a founder and CEO of several technology companies in the Middle East and the United States. With over a decade of cybersecurity experience, he continues to launch startups addressing current and future challenges. Anand is a board member and advisor to various startups and is recognized as an influencer in the technology industry. What better way to begin the panel this afternoon? Anand, may I request you to make your presentation?
Thank you, Justice Chansul, for that fine introduction, and thank you, the organizers, FICCI and ICA, for giving me this opportunity to speak here. I am the odd man out. I am not from the legal fraternity. I am here to give a perspective of where the technology trends are happening. Today, we are living in an era of disruption and innovation. Everything that we see around us is changing. The way we drive our cars, smart devices coming into our homes, everything that we saw was dumb today is becoming intelligent, is getting connected onto the internet. You can make it work from anywhere in the world, which also creates other problems of cybersecurity. The way we communicate is also changing. And in my opinion, emails would become, for example, traditional form of communication. Everything is moving towards chat services. We will not only use chat in our personal capacity as WhatsApp that we use today, but it is also going to become a professional way of communication. In the industry, if you look at acquisitions of Wickr by Amazon, Slack by Salesforce, this is the trend that shows that things are going to change. And accordingly, the evidences and will lie in these new forms of communication, which has to be factored into it. We're also seeing constant change in the ecosystem that we live in. All of you would remember a decade back, Nokia and BlackBerry were the #1 companies in the world to watch for. In just a matter of years, they have disappeared. Today, the largest media company in the world is YouTube. And YouTube does not own and create any of its own content. What a better example than Uber? They're the largest taxi company in the world, but don't even own a single taxi. That's what the change is happening. Another aspect of change that we are seeing is how we deal with money. I would like to kind of explain here the difference between money and currency. A lot of you would know it, but just for a few people who don't understand the perspective. Currency, a denomination of a dollar, a dirham, or a rupee, is, for example, 2,000 rupee note or 100 dirham note has a certain designated value which has been given to you by the regulator. What if a 2,000 rupee note is not valid anymore and is declared, the value goes to zero? We know about fiat currency. The countries are printing money, and that is going to bring in inflation. Those are the challenges that the world is seeing on the money front. But if you look at money, so that on the currency front, but if you look at money, money has a stored value. For example, gold. You can take it anywhere in the world and exchange it for any currency for a certain value. It is difficult, it cannot be easily printed like money. It has limited resources in the world. It has to be mined. That's what the concept is coming in cryptocurrency. People are believing that money has to have a stored value, which cannot be regulated. So these changes have to be adopted in the new regulations that we see coming to legalize it, to control it. And this technology, to give you a perspective, is based on blockchain. And what is blockchain? Blockchain, in simple terms, is a set of blocks that store the information. Each block typically would have 3 components: data, hash, and an address of previous hash. Now that data cannot be tampered, because the moment you change data, the hash, which is the identity of that box, changes. Now all of these is spread over a distributed ledger, not a single ledger. And the copy of the whole ledger is available with every user. Now all of these technologies are helping us in smart contracts, like the one we understood today. And my co-panelists are going to talk about it, how they're going to get it implemented in the arbitration cases. How can we make more secure? Again, in my opinion, the world is seeing 2 challenges. One is of biological warfare, which is a very big challenge. We've seen the impact of COVID, how it can impact everything that we do. And second is cybersecurity warfare. Because of the connected devices and we being everything on the internet, maybe in few years' time, the wars will only happen through cyber destruction. So all of these have to be incorporated into the way regulators are looking at it. It's always believed law is at the edge of the technology. So without taking much time, I would like to invite Linda. She is a classic example of all connecting using technology from London. So there you go.
So Lydia, may I take just 30 seconds with your permission? Well, Lydia Dannon, our next speaker, is a partner and solicitor advocate at Cook, Young and Caden, specialized disputes practice in London. She has a particular focus on tech disputes, civil fraud, and corporate disputes. Her clients include the New York Stock Exchange listed companies, high net worth individuals, investment funds, and their members and partners. She has worked on high value, complex, multi-jurisdictional claims, including in India and the Middle East. Lydia is ranked in the directories as up and coming in civil fraud and a next generation partner for commercial litigation. Lydia is a co-chair of the International Bar Association's Young Litigators Forum. Lydia, the floor is yours.
Good afternoon, everybody. I'm sorry I couldn't be with you today, but unfortunately, I have been in close contact with some people that have had COVID. And so whilst I don't have COVID myself, it does mean that I'm not able to travel to see you all today. So you have to get me from London instead. My part of the talk is going to deal with technology disputes in arbitration, particularly in relation to blockchain technology, crypto assets, non-fungible tokens, and smart contracts. I'll also touch upon the crypto market and just explain a bit why it's important to us as arbitral practitioners and lawyers who are working in that space, the kinds of disputes that we are seeing in the digital technology space, why arbitration is a good dispute resolution tool to be dealing with disputes in the digital technology space, the new rules on arbitration, which the learned judges kindly touched upon in his excellent opening speech, and I'll let you know about some high-profile arbitrations as well. So, as mentioned by the previous speaker, blockchain is effectively an open, distributed ledger that can record transactions between two parties efficiently and in a verifiable and permanent way. It is basically a decentralized platform that stores and distributes digital data across a number of networks in a highly secure manner. Cryptocurrency. I'm sure we've all heard about that because it is the buzzword of the day. This is a digital or virtual currency that is secured by cryptography, which makes it nearly impossible to counterfeit or double spend. Many cryptocurrencies are decentralized networks and they're based on the blockchain technology. The most famous, of course, is Bitcoin, but you will have heard of Ether, Ripple, Bitcoin Cash. Then we have non-fungible tokens. This is a unit of data, again, stored on the blockchain, and that certifies that a digital asset is unique. So unlike cryptocurrencies, which can be exchanged like for like, NFTs are not interchangeable, and they can be used to identify a unique asset, whether in the real or digital world. An NFT cannot be changed or amended. It is what it is on the blockchain. The learned judge has mentioned smart contracts and how they can be used all over the world. Insurance, we're seeing them dealing mainly in the art world, also in real estate, and they come with embedded smart contracts in themselves. When you're dealing with cryptocurrencies, you tend to work with exchanges. They function similarly to online brokerage platforms, and they provide customers with the tools to buy and sell digital currencies. NFTs, you have auction houses or conduits that provide peer-to-peer exchanges or peer-to-peer purchases of those NFTs, and those exchanges charge fees for their services, obviously. Now, a key aspect when working with the blockchain, cryptocurrencies, NFTs, is the anonymity or the pseudo-anonymity it brings. Users use a digital or blockchain wallet to manage and hold their cryptocurrencies. Wallets are tied to one or more specific keys or addresses. You'll have a private key, which the user has to themselves, and you'll have the public address for the blockchain, which everybody can see. And these are the identifiers of the asset, rather than the names or the identities of the person that holds that particular crypto assets. Digital wallets can be held on-chain, so they can be held on the blockchain in exchanges, or they can be held off-chain, so with a digital pen, but more like a USB, and that's a more secure way of holding your crypto asset. I say secure, you obviously don't want to lose it, because when you do lose it, it's gone forever. You can't put it back on the chain. So why is digital technology in the crypto market so important? So according to data from CoinMarketCap, there are different types of cryptocurrencies that exist in the world. It is a total market cap of $2.76 trillion, so that's higher than Apple's market cap. The crypto market is bigger than the 12 largest US banks combined. Adopters of crypto have been growing at an annual rate of 113%, and in conservative estimates, it's expected to have about 1 billion users by 2023 and 4 billion by 2030. So that's quite a big market. There's also a lot of money to be made. When I had my first Bitcoin case back in August 2017, Bitcoin was trading at around $2,500. I checked on Thursday, it's currently trading at $41,000 as of that date, and it's been as high as $58,000. More importantly, 52% of institutional investors own crypto assets, according to Fidelity's 2021 digital asset study, and a number of the top companies are launching projects in the digital asset space. So there's a lot of money to be made in this market, and obviously where there's a lot of money, there's going to be some disputes. So what kind of disputes are we seeing? The digital technology is unfortunately ripe for fraud. We're seeing a lot of personal wallets or exchanges being open to hacks. So in 2020, there were 28 attacks on crypto exchanges, the largest of which resulted in $200 million worth of crypto being stolen from a Singapore-based crypto exchange. The types of frauds that we are seeing are not new. They're confidence tricks, pump and dump schemes, as I say, they're hacks, selling counterfeit NFTs. These are types of new frauds, but of course we don't have arbitration clauses with fraudsters. So I'm not going to be talking about how we deal with arbitration against those fraudsters. But where we do see arbitration clauses? Well, with the exchanges, the kind of claims that you're going to be seeing are similar to those you would get with online brokerage platforms. So breach of contract, failed trades, frozen accounts, security breaches, erroneous coding or software glitches, which is a result in trades not happening or parties suffering loss. And there's also going to be the potential for IP and ownership disputes, co-founder, co-investor disputes, and these last type of disputes will take the form of your typical arbitration. So why is arbitration good for settling these kind of disputes? The crypto market is very dynamic. There is no unified governmental approach to the regulation of cryptocurrencies, NFTs, and to be honest, national lawmakers are struggling to keep up. Trading crypto assets is illegal in many countries, or in other places it's unregulated, which means that consumers, investors are not sufficiently protected, and they are at risk of losing a lot, if not all of their money. In addition, because of the pseudo-anonymity of the market, there is a risk of violating sanction regimes, money laundering laws, and terrorist financing regulations. So it's a minefield. But blockchain, cryptocurrency trading, it's borderless. The parties are going to be in lots of different jurisdictions. So it's not unreasonable to expect that investors would prefer a borderless and less traditional way of dispute resolution. Crypto investors tend to be a bit more anti-establishment, and so arbitration can be seen as more removed from national regulators or the company courts. And they tend to like the anonymity of or the confidentiality that arbitration would bring, because that's what the crypto asset also brings to them. The learned judge very kindly mentioned a number of the other key aspects that is good why arbitration is good for us. So you get to pick your arbitrator, it's flexible, you can do the arbitration virtually. You can also appoint arbitrators on an expedited basis, so that could lead to procedural economy and cost saving. It also has the benefit of global enforcement, which goes hand in hand with the borderless nature of blockchain. But of course, much will depend on the law of the country in which you are looking to enforce an award. So, for example, the Chinese government recently refused to enforce an arbitral award issued in China on public policy grounds. The dispute related to the failure to transfer a certain sum of Bitcoin. The award was given in the fiat equivalent of the Bitcoin sum, but the Chinese court was concerned that the enforcement of the award would facilitate the circulation of crypto in China, which is contrary to Chinese law, and so it wasn't enforced. So you always have to be prepared for enforceability. Now, touching on the arbitral rules, it is certainly possible to arbitrate digital disputes on existing rules, LCIA, ICC, but as the learned judge mentioned, there are now moves to create specialist set of digital dispute resolution rules, and the UK has certainly done that. I've not seen anything myself with that, but I'm sure it will happen shortly. I think the rules were only published in the middle of last year. Some other key factors about those rules that were not necessarily touched upon by the learned judge. The aims of those particular rules is to try and get a result within 30 days, which is pretty quick, but is likely to be able to be done if you are dealing with disputes just relating to transfer of crypto assets or NFTs, but less likely to be achievable if you're dealing with disputes relating to coding errors, for example. The rules also give the arbitrator the power over the digital asset. So they are able to make amendments to the blockchain. So effectively, they're able to enforce any decision that they make almost immediately. And of course, touching upon the confidentiality point, it is possible that the two parties to the arbitration remain anonymous to each other, and they are only known to the arbitrator. And this again, protects the anonymity of the crypto investors. Parties must elect to adopt these rules. They can be incorporated into the contract or the digital asset. But this may raise some challenges, because for there to be a valid arbitral agreement, there has to be a common necessary understanding between the parties. And if the agreement is in code, a party could certainly argue that they were unaware of the presence of that arbitral agreement. There's also some other issues. So with the arbitrator having the power to amend the code, this is great power. And the arbitrator may have limited oversight or regulation. To amend the code, the arbitrator would also need the parties' private keys, and they may be reluctant to provide this information to the arbitrator, particularly because of security issues. The arbitrator could be hacked whilst holding that key, and the assets could be lost. The arbitrator may also not want to take risk of that liability. If it's decided that there's not going to be immediate enforcement, but there's going to be enforcement under the convention, if you go to domestic courts and try to seek to enforce, you have to provide evidence of the original arbitral agreement, and it recognises letters and telegrams, but it doesn't necessarily recognise digital code. So it's unclear how domestic courts are going to be dealing with that. And there's also issues about no right to appeal the arbitral decision. And there's a question mark as to whether investors would want to take on that risk. So lots of issues to be dealing with there. A couple of high-profile arbitrations that we know about. In September 2021, Nifty Gateway, which is an NFT auction house, began an arbitral claim against one of its bidders. the unpaid price of an allegedly successful bid on an NFT, and they subsequently froze the bidder's account. The bidder claims that the terms and conditions relevant to his account were changed prior to his bid, and he was not made aware of the changes. So he's now issued claims in New York and the English courts, claiming, amongst other things, that the arbitration agreement is in breach of UK consumer rights legislation. So we're already seeing challenges to those kind of agreements. Binance, which is a large crypto exchange, there's reportedly been an arbitration issued in Hong Kong to recover losses suffered during an outage of the platform, during which time cryptocurrency values fell very sharply, and obviously the customers lost money there. And then back in 2020, a class action was brought against a lending platform, MakerDAO, for claims that the owners had misrepresented to the users the risks of the investment. And this class action was stayed in around September 2020 to be sent to arbitration. So there is that flexibility between the High Court and the arbitration and kind of resolving these disputes. So we are seeing them. They're certainly rising. And I can say that you can expect this to be the future of these types of disputes. That's it from me.
Thank you, Lydia. That's really truly was a fascinating exposition. Fascinating for me, particularly as a judge, in getting to know the new developments which are taking place. Our next speaker, Karishma Vora, is a barrister specializing in banking, private equity, and technology. She is frequently instructed by business owners and fund managers in both arbitration as well as court work. Karishma has successfully represented a corporate guarantor in one of the largest cases at the DIFC courts last year, appearing against heavyweight QCs, and she's doing path-breaking work in the field of cryptocurrency and technology fraud at the High Court in London. She's ranked by the legal directories in Band 1 for commercial disputes in Dubai and the Middle East, and is a member of 39 Essex chambers in London. Karishma has been practice for 16 years. So, Karishma, may I request you now to make your presentation?
Thank you very much, ICA, for hosting all of us and always putting on a good show. Thank you all also to the speakers, many of you who've flown.
I'm sorry, Karishma, but your voice is not carrying through, so we just request the organizers.
Is this better?
Yes, it is. Thank you.
Thank you. Thank you also to all of the speakers, some of you who have flown from around the world to make it here today, to share your time and knowledge, but also for your cooperation. This was supposed to have taken place in January, and it was only one message to every speaker who responded to say, yes, don't worry, we will make it in March, so thank you. And Justice Chandrachud, this would not be complete without thanking you, because it is judges like you, Mrs. Geeta Luthra, Senior Counsel, earlier today said, you encourage juniors, and I know that from experience. I was only 1 year into my profession at the Bombay High Court when a senior was not present, and you encouraged me to go ahead with the arguments, which I happily did, and it's only because I honed my skills in India at the Bombay High Court that I was able to stand before the High Court in London, so thank you. It's the first time that the ICA has adopted technology as one of its subjects for its conference. And rightly so, the reason that we decided to do that is because, and of course I speak for myself, but it's probably true for most of the panelists, about 5 or 6 years ago, if you would have asked us how many of our private equity disputes are technology-driven or have aspects of technology, we may have said 0, maybe 1, maybe. But now, if you ask us, it's mostly 50%. So a lot of the underlying investments in private equity are in technology companies, or there is a major element of technology in the arbitration. So we're here today. Dubai is also emerging as one of the crypto capitals of the world. A lot of founders of crypto exchanges from around the world are making their way to Dubai. I mean, it's become such that one can go to a bar in Dubai and the person sitting next to you at the bar stool will be the founder of a crypto exchange. So it's good to be here. And before I proceed to the two topics that I will cover, crypto fraud and ERP disputes, it would be useful to explain how AI is already being used in mediation and arbitration. An Australian court, a family court, has replaced one of its mediators as an AI machine. Some of you may know that in divorces around the world, it's quite common to have compulsory mediation. And this particular Australian court has developed a system by which the husband and wife, or the parties getting divorced, make their submissions to this AI software. And statistically, they have mapped that this AI software produces the same result up to 90% as a judge of the family court. And this has encouraged settlements without the involvement of court time, because parties believe that if the AI matches the judicial decision about 90%, then let's save our costs and settle on the basis of whatever that AI software has said. So this is successful mediation using AI. An example of arbitration is something that maybe everybody in this room would be aware about, eBay. eBay is a company where you can buy or sell anything. For example, this lectern, it's become too old, I want to get a new one, I work for the Oberoi, I put it up on eBay so that someone else can make better use of it, someone comes and buys it. So on a daily basis, what do you think happens? There are lots of disputes between these buyers and sellers, and they're really small value, maybe $10, maybe $30 or something like that. So how does one devote the kind of resources that are needed to resolve disputes of such small value? So eBay has developed successfully an AI arbitrator that resolves these disputes, and that AI arbitrator has resolved about tens of thousands of these disputes. There is no reason why we cannot implement that, for example, within small claims disputes around the world, in particular within a jurisdiction such as India, where there's a significant backlog of cases. Perhaps AI could be replaced, at least for small value claims. Moving swiftly on to crypto fraud. It is a hot topic. It is something that Lydia touched upon as well. I will focus, therefore, only on the interim measures of crypto fraud, which is basically, if you are defrauded, if you've had crypto, what do you do? It also ties in with other kinds of fraud, such as email compromise fraud. For example, let's say you are a seller in Vietnam who's selling something to a company in China, and payments are coming in regularly, but one letter from the email has been changed, and you can't really tell. Let's say an I has been changed to an L, and that by way of that, the fraudster communicates and says, oh, we're having some issues, our bank account details have changed, don't pay this bank account anymore, pay it to this other bank account. And that's what you end up doing, and you don't realize until the seller, after maybe a couple of months, or it depends on what your credit cycle is, comes back to you and says, hey, by the way, you have not paid anything for the last couple of months. So what do you do in a situation such as this? The first thing is you want to go to court and you want to tell the court, please, can you help me? I have been defrauded. What is the court going to say? Well, who have you been defrauded by? And you will say, actually, I don't know. Someone in the cyberspace, someone in ether. So this has become a serious problem, because who do you sue? So the first step in a situation such as this is called a Norwich Pharmacal Order. And it's basically going to the court and telling the court, I have some details, but really not the whole picture. So can you help me find the identity of those who have defrauded me? In the case of a crypto fraud, for example, you can go to the crypto exchange, or you can have the court order that the crypto exchange, or even an internet service provider such as Etisalat or Airtel or Sky, reveal their KYC data and whatever other name, address, and contact details that they have for the fraudsters. So when you make this application to court, now what is the difficulty with court? It's not a difficulty, it was originally an advantage. that a court is always open. Justice is in the open. So anybody, any member who's sitting in this room can walk into any courtroom and view any proceeding, because justice must be done in the open. Now, if this happens, what is going to happen? The fraudster is also going to find out, oh, they're trying to actually pursue me. So what is the fraudster going to do? At the click of a button, just transfer all of the crypto, siphon it away. So one has to think very carefully and obtain interim confidentiality orders and gagging orders to make sure that the court proceedings are behind closed doors or taking place in private. All of this takes time, and this also means that you're giving more time to the fraudsters to siphon away the crypto or whatever it is that they have taken away from you. Now, this problem doesn't actually arise in arbitration, because an arbitration is confidential by its nature. It is always behind closed doors, and that makes it a great advantage when you're dealing with a situation such as this. The second aspect of this is, once you find out the identities of these fraudsters from, let's say, crypto exchanges, etc., and you want to serve them, what do? The difficulty, once again, with crypto is that a fraudster might be in one person in the Marshall Islands, another person sitting somewhere else, let's say in Bali or somewhere, and defrauding you sitting on the beach or something like that. How are you going to be able to get to them? Again, with courts, they're very nation-specific. Courts, for example, the DIFC courts have a jurisdiction that is limited to the DIFC. The onshore Dubai courts are limited to the onshore jurisdiction. Indian courts are limited to India, and so on. So if I were before a court of England, it would say, well, Ms. Vora, you're here, all of that is fine, but why should I, or rather, what power do I have to adjudicate on something that someone in a foreign jurisdiction has done? So the answer to that has been explained in one of the white papers that has been published by the UK, which says that if the crypto has been purchased by someone within this jurisdiction, within the United Kingdom, then the situs or the location of that crypto is deemed to be within the UK, which is the best that we can do, because really crypto can be anywhere. It doesn't necessarily have to be within one particular jurisdiction. So making a submission on that basis, I might get permission and I might be able to pursue the court in London to say, please allow me to now serve these proceedings to someone who's sitting outside of England and Wales. Again, in the context of an arbitration, that doesn't happen. An arbitrator can be, for example, a Brazilian arbitrator can be arbitrating a dispute between, let's say, another Latin American country and the United States. And there doesn't need to be any permission sought from the arbitrator to be able to serve these proceedings on the other parties. So that also makes it seamless, and it's something that is worth considering. My third and final point for this, and I'll make it brief, is once you know who the fraudster is, you've got all these permissions and so on, what do you want to do? You obviously want to freeze their bank accounts, right? Or you want to freeze their crypto accounts. So when we bring freezing injunctions, this is the only real difficulty that we have, because arbitrations cannot do this. Even if an arbitrator says, yes, I'm happy to grant you this, this order where you can go off and freeze an account in the Marshall Islands, because it is not a final order, and it's an interim order, because the person from the Marshall Islands can come back and say, oh, no, I'm completely innocent, I was caught in the middle of this, you should lift the freezing injunction. And if when they come back, it's a genuine story, and they were genuinely an innocent party, the freezing injunction will be lifted, which means it's not final, it's an interim award. And an interim arbitration award is not enforceable under the New York Convention. And this is something that we need to think about when we are thinking about futuristic laws for digital assets and virtual assets and so on, because there are a lot of advantages that arbitration can provide, but we need to go a step further to ensure that immediate steps for protection can be enforced around the world. I think we have overrun significantly, so perhaps I should not speak about ERP disputes. And if we have time later, Dr. Chandrachud, I might come back at your indication. Thank you.
Thank you very much. Thank you, Karishma. Your innate knowledge of the subject and its intricacy is really shone through your presentation, Karishma. Speaking for myself, let me just tell you that one of the best moments of a life in judging is what I just encountered a short while ago, which is when an internationally renowned counsel remembers a day in court several years ago before the judge when she was a junior counsel. Well, that's what makes judging so satisfying for people like me. So thank you very much for remembering that. And our final speaker for this afternoon is Vyapak Desai. Vyapak heads the International Dispute Resolution and Investigation Practice at Nishit Desai Associates. Vyapak is known for his innovative and solution-oriented approach as a counsel in cross-border and complex contentious matters. He also acts as arbitrator and mediator across jurisdictions such as London, Singapore, Malaysia, and India. Vyapak is the co-chair counsel of the MCIA, the director of CIARB India branch, the convener of the Indian Arbitration Forum, a member of the ICC India group, co-chair of the Society of Construction Law, the India Western India chapter, and the member advisory council of the AIAC Malaysia and the advisory board at MERC Mauritius. Vyapak, the floor is yours.
Thank you, everyone, and thank you for staying so agile after the lunch as well. And thank you, Mr. Chawla, FICCI, and ICA for this conference. While I think Karishma remembers Justice Chandrachud as a judge, and that shows why she is a good counsel, I think my journey also possibly began because of Justice Chandrachud, but not as a judge, but as a counsel. And he may not know, but I was in the corridors of Gujarat High Court when he was a senior advocate and arguing a matter which I overheard as an intern, which possibly has big inspiration on my becoming a lawyer and where I am. So again, thank you, not only as a judge, but as a counsel to inspire so many people across India. So I think while Justice Chandrachud did say that technology and arbitration, it's so easy to talk as if they are two coexisting phenomena. But I would say 15 years back, if you had Googled technology plus arbitration, possibly you may have found only a couple of pages or something, because I don't think people used to think that much the way we talk about technology and arbitration today. In those days, conference used to talk about what is seat, what is venue, how can you enforce awards, which are the good arbitrators, how can you avoid conflict of interest, and so on and so forth. I don't think technology ever came as a part of subject in arbitration conferences. But thanks to FICCI, ICA, and some of the organizers here to bring this topic. And soon, possibly, not only in the conferences, I think technology and arbitration has gone much, much ahead in times. And I think from where we were, where technology was just an enabler and part of our, universe, I think we have already moved into metaverse, right? And possibly this is for FICCI and Mr. Khetan. Next international conference can be on metaverse. We can have different avatars, and possibly same thing will happen with arbitrations. It can happen in a virtual world. And in fact, one of my colleagues was recently quoted in a print media article where there were complaints filed for different avatars making a complaint that somebody was stalking and harassing in a metaverse situation, and how to deal with those complaints, whether they can be arbitrated, which courts would take into account, and so on and so forth. So I think the challenges which this technology is throwing up in dispute resolution is enormous. But I heard in the first two sessions that challenges also gives opportunities for lawyers like us to talk about newer things in conference and continue conferencing. And that's why we exist. So I think there are two parts of technology when it comes to arbitration. I think the first part is technology in arbitration, right? I think we have seen enough talked about and written about of online dispute resolution systems. I think AI, Karishma talked about as how AI is being used to adjudicate disputes for smaller claims, non-complex claims, family disputes, and so on and so forth. So I think technology is already part of the online dispute resolution system, and it is nothing but mediation or an arbitration, but done by technology. Second, virtual hearings. I think COVID taught us everything about technology in dispute resolution, particularly in arbitration and in court system. So that is pretty much there. But one another aspect of technology in arbitration which possibly will become a big reality soon, and we have talked about blockchain a lot, but I think one of the usage of the blockchain technology that people are contemplating is actually writing awards on a blockchain. They would be possibly self-executory awards. Then what happens to the New York Convention for execution and enforcement of awards, right? That would be the topic possibly for the next conference, because this award written on blockchain would be nothing but similar to a smart contract, where maybe certain tradable or traceable assets can be already granted as part of a self-executing award, and you may not require to go courts to courts or jurisdiction to jurisdictions to recognize and enforce those awards, and how international conventions and local domestic laws would treat those awards, whether they would be treated as written award, whether they would be treated as virtual awards, whether they would be treated as New York Convention awards, and I'm sure there would be several other questions which can be a topic in itself for a full session. The other part of the blockchain awards written on blockchain would be also authenticity. I think today, if you really see what are the elements for recognition and enforcement of an international award, the first terms and conditions or first precondition to an enforcement of an international award is authenticity. You need to supply to the court the original or the authenticated copy of the award, and possibly an award using this technology can be self-authenticated, and there are several papers written on this, and it's a fascinating subject and a detailed subject by its own, but for the want of time, I'm just throwing up as an aspect for the purpose of how awards and technology going forward, particularly on the blockchain, can completely change how enforcement of awards would happen. Now, that's only one part of technology in arbitration. I think the second part of the issues are arbitrating the technology disputes, right? I think at least at Nishit Desai Associates, we strongly believe that every technology which is coming up and in future would come up with through a lot of tax, legal and regulatory aspects, and which requires a fair amount of changes in the dispute resolution mechanism. I think when we talked about technology disputes, earlier we used to talk about, let's say, disputes arising out of software contracts, disputes arising of licensing contracts or outsourcing contracts. But at the end of the day, while a lot of technology was involved, a lot of SOPs were being interpreted, but at the end of the day, it was still a contract related to certain technologies which was going into disputes and arbitrated. So that was the first phase, I would say, where technology disputes came into the foray of dispute resolution, particularly arbitration. The second phase was the debate all along as to whether IP disputes related to technology can be arbitrated or not. I think, again, in the initial sessions and also during our plenary, people talked about the aspects of what can be arbitrated and what cannot be arbitrated. Basically, it's the rights in rem and rights in personam. And I think we have moved pretty far in that process as to even aspects related to the applicability of patents, or even issues related to copyrights, and trademarks, and there are many other contractual aspects to those IP rights which can still be arbitrated. So that was, I think, the second phase of debate, and we have gone further down, much ahead in times. The third phase, I would put it, is when internet became what internet is today. I think there were so many discussions happening about how to resolve the domain name disputes, where is the jurisdiction, who owns it, who doesn't own it, where you go. But I think with several bilateral and multilateral, conventions and coming up with right approach, I think those aspects also, in a combination of dispute resolution, of arbitration and adjudication, I think we have moved pretty ahead in those times, and they are all settled so far as we are concerned. Then came the issues related to confidentiality, data privacy, and cyber security, which I think Anand also mentioned. And again, those also, I think we are today grappling and taking advantage of the arbitration procedures. I think this is the phase which is the most, in my view, today the phase that we are in is the most challenging phase, because the way the technology is intruding in everyday life, whether it is IoT-driven technology, whether it is AI, whether smart contracts, I think everybody talked about on our panel, and how self-executory those smart contracts are, how to bring in arbitration there. The whole technology on distributed ledger, which runs on several, authenticity brought in by distributed networks rather than a method where there is some centralization of the contract management. And of course, the flavor of the day, the crypto currency or the crypto or virtual assets. So today, what possibly in next 2 to 3 minutes, let me deal with what are the major issues which the smart contracts or virtual data or virtual digital assets and things which are related to the future technologies, let's say driverless cars. And Justice Chandrachud also mentioned that who would be the responsible party, right, when there is an accident. Same thing happens if there is a robotic surgery done from one jurisdiction to another, then where and who is responsible, and which courts or which arbitration can work for resolving those disputes. How do you bring in, ultimately arbitration is all about party autonomy and agreement of parties to do a arbitration. So how do you bring that element without taking away the very nature and mission and vision for the arbitration as such, in those kind of situations where it is more of a technology-driven disputes rather than parties having the autonomy to decide whether to arbitrate or not. And of course, we have already dealt with the issues on Evidence Act as to whether, how electronic evidence can be dealt with. I think we have gone much ahead in the situation there. But I think how evidence would be led in those situations will be another topic for the regulators and lawmakers to decide, particularly in the situation of virtual assets and smart contracts. So I think there is a lot of work already in progress. There is, when it comes to smart contract, I think the suggestion is, and one of the solutions a lot of people are, talking about is, while there are automatic codes and self-executory smart contracts, but there is also a manual element of, adding something called a wrapper on a smart code, which can possibly include an arbitration clause between those parties who are entering into, or at least party to those smart contracts. Whether again it would deal with party autonomy or not, it would depend upon how those wrappers are written and the codes are made. But that is one way of dealing with it. When it comes to exchanges and cryptocurrency, I think there is already the actions are already in place to have arbitration clauses in the user agreement or terms and conditions, so that if there is any element of dispute in relation to the ownership or transfer or any fraud related to the exchange of those virtual assets, then arbitration can be implemented as part of the terms and conditions as a user to those exchanges. In terms specifically to arbitration, I think some of the institutions and have already made foray into it. At least I was reading somewhere that JAMS in US have already certain rules implemented for smart contracts arbitrations. There can be situations where arbitrators are appointed through those smart contracts, giving very narrow but specific powers to even change the code or implement the code in a manner depending upon how the original smart contract was about to perform and what are the disputes related to or non-performance related to those smart contracts. So I think there are institutions like JAMS already dealing with those situations. Again, Justice Chandrachud talked about the digital dispute resolution rules by one of the UK task force. And interestingly, at least those rules which are already in place, and they are obviously subject to further development, talks about reference of arbitration in the smart contracts when the codes are written. So far as on-chain arbitrations are concerned and the smart contracts are concerned, I think there is a proposal in those rules to, as I said, to give the powers to the arbitrator to at least implement or change the code. Of course, that would require another set of, I would say, skill set for that arbitrator or at least parties to implement. But in those cases, you can even maintain anonymity from one party to another party while arbitrator is appointed for a limited purpose to deal with those kind of disputes. There is another proposal where there can be different keys for, let's say, a payment has to be made for certain actions to be taken on a smart contract. Then there can be an additional third key to a neutral so that if the first and the second one do not authenticate or there is a dispute, there is an automatic referral to the third person or the neutral who has the key would then confirm, like an arbitrator, whether it's an arbitration process or not would again depend upon how things progress in that direction, but a multi-party keys to authenticate certain transaction on smart contracts can deal with it. The last point, I think everyone talked about crypto assets. So again, I think a lot is happening throughout the world. Just to give you a snapshot, so far as India is concerned, for the first time, we have now a definition of what virtual digital assets are. We also have regulations to tax transactions in virtual digital assets. So in some form, it's coming into the regulations, but again, we don't know how those would get implemented. They are all happening as we speak. There was already recently an executive order specifically dealing with international cooperation on the crypto transaction by the US president, and that was even the Indian Prime Minister talked about. So we will see a lot of multilateral and bilateral agreements coming up to deal with those kind of assets and those kind of disputes in terms of smart contracts or the crypto or the virtual assets. I think Dubai is, I think Karishma mentioned, is possibly in the forefront of all of this. I think there is already a law in place in the Dubai region except for the DIFC, where a common regulator is already proposed to deal with these issues, including the securities regulator has brought in rules for anti-money laundering and avoiding any terrorist financing. DIFC has also issued a consultation paper dealing with three kinds of crypto assets. One, they call it crypto tokens, which are more of medium of exchange. Second is the excluded tokens, which are based on the utility those token gives. And the third is the NFTs or the CBDCs, which I think Lydia also mentioned. So I think that, again, how those disputes can again be brought into the dispute resolution system is what we would be, as a group here and elsewhere would be working on as to how this can also be arbitrated. And EU is also in line with all of this, where they have already suggested a uniform legal, framework. The Economic and Monetary Committee has suggested that. But they also deal with the issues of consumer protection and sustainability as to how this kind of, digital contracts, particularly on the crypto or the virtual assets, can deal with the world economy, maintaining the sustainability around it. And that also again differentiates between the crypto assets and the the tokens or the stable coins as we understand. So I think a lot is happening. While we have seen the progress very slow in last 15 years, but I'm sure if we are going to have this conference again next year here in Dubai, we will have something very, very different, and things would have progressed from where we are, and we would have gone a long way because the way things are moving. So as arbitration lawyers, as practitioners, I think this is something which we cannot, avoid or sleep over it. I think this is something which is developing as we speak. And I'm sure arbitration, the flexibility and the party autonomy, while it can be a deterrent in a digital world, but actually it can be used as an opportunity to bring those disputes and embrace as part of arbitration rather than push it to courts, where again the issues related to jurisdiction or issues related to traceability and other things become even more difficult to implement, while arbitration is much more flexible, to include some of these aspects that I was talking about. So again, I don't want to go too far and too long, but thanks again for FICCI to give this opportunity, and I'm sure we'll be back again soon, possibly just talking about this the whole day. Thank you.
Thank you very much, Vyapak, and thank you particularly for remembering that brief exchange in the corridors of the Gujarat High Court several years ago. Well, I've been requested by the organizers that we have overrun our time, so I'll conclude with just telling you what Professor Richard Susskind has said, and which is that as our societies springboard into a new world, we still really are at the foothills. And I would only add this, that perhaps we are at the deep end as well. And this afternoon's session has given us plenty to ponder upon, reflect, to think over, as we've shared the platform with some of the most distinguished practitioners in the science and art of technology and its interface with disputes. Mr. Chawla, FICCI and ICA, thank you very much for giving us this opportunity. And may I now request a round of applause for all the distinguished panelists who've given us their views on the subject.
Justice Chandrachud, let me just confess, this has been a very informative, very interesting session. And without you, we would not have known so many other things, not only about technology, but the fact that how you've inspired and motivated the young practitioners in life. So thank you very much for coming online. And we will conclude this session with one big round of applause for you and the practitioners. Ladies and gentlemen, it's time for us to move into another very interesting session. Yeah. So, ladies and gentlemen, we are fortunate to have amidst us the chair for this session, Honorable Ms. Justice Hema Kohli, Judge, Supreme Court of India. May I invite her to take the dais along with her panelists. Of course, any introduction to Justice Kohli would be incomplete and would fall short of the significant contribution that she has made to the development of jurisprudence in the areas of environment and arbitration. Left her lucrative practice as an advocate to become a judge of the Delhi High Court, went on to become the Chief Justice of the Telangana High Court, a very prominent state in India, before getting elevated to the Supreme Court soon thereafter. Known for a keen interest in the area of mediation, Justice Kohli is a votary of alternate dispute mechanisms even while sitting on the bench. Ladies and gentlemen, please welcome her and the esteemed panel of speakers for the next session, while I request Mr. Khetan to come and present the green certificate to Justice Kohli. Again, a pledge by us to plant 6 trees in her name on the outskirts of the National Park Sundarbans in West Bengal. I will now request Justice Kohli to take the lead and deliver a keynote remarks before conducting the session. Thank you.
Very good afternoon. We thought that we've had a lot of sessions where most of us have gone across to the podium and addressed you, and it's post-lunch. In fact, on a good, long weekend, perhaps many of us would have slipped from being lazy to sleepy. And keeping that in mind, and picking up the thread from what Vyapak said a minute ago about sleeping over things, we want to shake you and stir you. And one of the ways of doing that was perhaps for us to change the format of our interaction. And keeping in mind that there's a time, we are running against time, it's an hour and a half beyond what should have been the scheduled session. We propose to tweak it and make it shorter, but we hope it's a bit more interesting and engaging so that we are all alive to the cause that we have highlighted here, which is MEDAB, developing an international model. On behalf of all my panelists, I must start by thanking Vicky at ICA for organizing this particular conference. It has been touch and go because we were all to meet in January. We have ended up meeting in the month of March, but it's never too late for something like this. So we set the ball rolling and permit us to cut short the time, but not trotting up to the podium ever so often. So here we are, seated and exchanging notes, and perhaps giving some space for some Q&As at the end of the session. Thank you. So we are not giving our keynote address, and I'm just starting the subject and setting the ball rolling. MEDAB is the subject, as we all know. And what is MEDAB? MEDAB is like an arbitration, an agreement in writing, which is a prerequisite, where mediation is specified as the primary ADR process, sequentially followed by the process of arbitration in respect of unresolved disputes. The parties who opt for MEDAB process have a step clause in the contract that provides the disputing parties a possibility of early settlement at the mediation stage, and if the mediation ends in an impasse or the issue remains unresolved, the parties move on to the arbitration stage that entails a finality. So this mechanism has an elasticity to switch between mediation and arbitration and accesses the best features of both the ADR mechanisms. That is why this form of ADR is also called as the mediation with a muscle, as it allows the parties to be flexible but at the end has an element of arbitration for resolving the disputes that remain unresolved. It has its benefits. It has also some pitfalls, which we will discuss with you here. And I'll start by the first question that I intend to put in this session to Sachin, followed by Philip and Francis. I'll request the organizers to run my esteemed colleagues in the session's CVs in the background. Just to inform you, Sachin Trika is a partner of Clifford Chance, London. Francis Xaviers is the SC Regional Head, Raja and Tan, Singapore. Philip is a partner in Gunnar Coke, LLP, London. And Paul Hughes is a partner in Cobre and Kim, Dubai. So the first question goes to Sachin. He's our opening batsman in every which way. Sachin, should mediation be mandatory?
Sorry for the false start there, Josh. And I regret, I think, by saying that my answer is, I think, no to that question of whether mediation should be compulsory or mandatory. But I think perhaps it's a soft no rather than a firm no, because I do appreciate that mediation can be a mighty effective tool in resolving disputes amicably, fairly, quickly. But my principal reason for opposing mandatory mediation is, I think, the circumstances prevailing at the time a dispute arises, and the contrast between those circumstances and the circumstances when the parties have executed their matrix contract and their dispute resolution clause within it. At that point in time, I think it's fair to say that the parties are optimistic, they are enthusiastic, they are positive. The prospect of resolving disagreements by way of a 18-month costly, contentious arbitration is perhaps the last thing they want to do, a last resort. And it's quite common to see those multi-tiered dispute resolution clauses where mediation is a step on that journey. But I must say, in my experience, it's usually an optional step in that journey. And I think the reason is because when the dispute does arise, that optimism, that positivity has been replaced by hostility, perhaps distrust, and the circumstances that may lead to a successful mediation, the willingness to cooperate, to concede, to compromise, may just simply not be there. With the consequence that I think a mandatory mediation may, in certain circumstances, be fruitless and perhaps delay the resolution of a dispute rather than facilitate it. Just one final comment. I think the circumstances in an international commercial arbitration are different to a court litigation, because I think in a court litigation context, there is an additional reason as to why it may make sense to try and resolve a dispute quickly and early, and that is, of course, that the courts are a public resource and there is a public interest to perhaps protect the scarcity of that resource and encourage people even more so to resolve their disputes outside of the court system. I'm not quite sure that same policy factor applies in the context of international commercial arbitration. Those are my 2 cents, Judge.
Thank you, Sachin. And we go on to Philip, who wants to support the idea of mediation being made mandatory. Philip, please give us your perspective.
Thank you very much. I disagree with almost everything Sachin said. No, it's not quite true. But there are a lot of things I disagree with there. I make no secret that I am a supporter of compulsory pre-action mediation, and I am at the moment trying to persuade the UK government to introduce a new law whereby all commercial disputes have to go to compulsory mediation. And I have, from my experience, the problem with the situation we have at the moment is that often mediation takes place too late. The parties are wholly entrenched in their positions, and a vast sum of money has been spent on legal fees. And often the most difficult issue to resolve at the mediation is not the underlying dispute, but actually who's going to pay who, what, legal fees, when, etc., etc. I've got 4 reasons that I think that mediation should be made compulsory. Firstly, it allows the parties to consider their legal and commercial positions at an early stage. And it might be possible to save a commercial relationship. What happens, of course, is that once arbitration is commenced or one's in serious throes of arbitration, the chances of saving the commercial relationship are very slim indeed. Secondly, problem with not having compulsory mediation is that often it's a sign of weakness on one party or the other to put that forward as a potential solution. So with compulsory mediation, that issue doesn't arise because it will be bound in law. Thirdly, it also keeps costs in check. Early mediation, hopefully not too much money has been spent on legals. And fourthly, it of course allows the parties themselves to resolve the dispute. Once it's got into arbitration, of course, it's the arbitrator who actually makes the final decision. So without further ado, I'll pass on to someone else.
Thank you, Philip, for your input. Francis has a treaty perspective to give to this question, which he'll just share with us.
Now, frankly, on the treaty side, up to about 10 years ago, mediation was practically non-existent in treaty provisions. But by late 2019, 10% of practically all treaties around the globe, our best estimate is at about 900 or so, 10% of these global treaties had mandatory mediation or conciliation. So that's quite a development. And by late 2019 also, 1/3 of all treaty disputes were being resolved before the arbitral ruling. And in 2020, Queen Mary did a study. 64% of respondents voted in favor of mandatory mediation as a precondition to ISDS. And you will all know that in 2020, September, the Singapore Mediation Convention came into force, giving teeth to enforceability of mediated settlements. So the sense is that in the treaty sphere at least, mediation is going to increase its presence. Mandatory mediation is almost going to become a feature in treaty arbitration in the future. Back to you, Jai.
Thank you. Just to update you on the Indian angle, the Commercial Courts Act in India has a specific provision, Section 12A, which talks of pre-institution mediation and settlement, and states that a suit which does not contemplate any urgent interim relief under the Act shall not be instituted, emphasis being on shall not, be instituted unless the plaintiff exhausts the remedy of pre-institution mediation as per the rules laid down. So that is the emphasis the statute in India has given to pre-institution mediation and settlement, with the idea that they can throw out matters which can be resolved at the pre-litigation stage itself, instead of clogging the system with and burdening it with a whole lot of litigation that could have been avoided. So that has been the Indian perspective. This happened in 2018, and the pandemic broke just about in 20, so we don't have the data as of now to be able to tell you how effective it has been. It shall take a bit of time, perhaps, if things remain as normal as they are today, for us to come back with figures on this. So this takes care of the first question. The second question that I would like to put to the panelists are, should double hatting be allowed For example, an arbitrator acting as a mediator. Paul would tell us something about the concept of what double hatting is and what is his perspective in UAE.
Thank you, Judge. So yes, double hatting, that's where the arbitrator who's been appointed also acts as a mediator to the parties' dispute. And what usually happens is that an arbitration is commenced, submissions are put in, and the arbitration pauses so that that arbitrator can act as a mediator in a mediation process. Now, the obvious advantage there is that the arbitrator is read into the facts already. You don't need to pay a mediator to read up on the facts, and the arbitrator is very closely onto the facts at that point. The arbitrator then acts wearing the mediator hat, listens to the parties' arguments, looks at the submissions, and gives effectively an early indication on merits, and the parties get to know which way the wind is blowing effectively. Now, it's quite an innovative process, and it's very popular in civil law jurisdictions because if you think about it in civil law, it's very submission-based, written submission-based, and so a lot of the arguments are in those written submissions and the arbitrator has them. For common law practitioners who rely on 6 months of disclosure and 3 weeks of evidentiary hearings, it's a nightmare for them. Also, as someone who's experienced in enforcement actions in the UAE, they're also fraught with danger. I mentioned one of the key benefits, and that is the cost. But for me, the cost of a separate mediator coming in and brushing up on the facts is minimal if you're talking quite a valuable dispute here. So the key benefit really for this double hatting is this. The parties will get an indication from the arbitrator who is going to ultimately decide their case and issue an award. They get an indication very early on as to which way, what the arbitrator is thinking. And the idea is that then forces the parties to reevaluate their bargaining positions, and that in turn helps them do a deal. Now, that's a very sort of noble issue to point towards. However, my take on it, in my experience, is that if your client is the one who's received this favourable indication, I'm sure most lawyers in the room, understand that a client who thinks that they are 100% in the right is a very dangerous thing, and so they may actually pull away from doing a deal because they think that their arbitration award is something of certainty, and why should they offer any kind of discount? Now, the party who's been on the receiving end of the unfavourable indication equally could begin to perhaps not bother with the merits of the proceedings and switch towards a disruptive role. Again, we see that quite regularly in this region. If they've got an indication that based on many submissions already put in, that the arbitrator is going to find against them, then they may start, reserving their rights on certain things, perhaps, using the fact that the arbitrator has, one argument is the arbitrator's got a preconceived, as a prejudged merits effectively, use that in terms of enforcement. So for me, it's the potential risks, certainly in this jurisdiction. Now, I know it's very popular in China and other civil law jurisdictions, but for me in this jurisdiction, it's fraught with risks.
Thank you, Paul. Philip.
I can only talk about my personal experience, but I've never come across a situation where in an arbitration, the arbitrator's changed hats and has become mediator. And my concern is that, firstly, I think the mediator stroke arbitrator, he or she could get sued in terms of what knowledge have they gained whilst acting as a mediator. What confidential information are they now aware of, which they only became aware of in their capacity as a mediator. And I think that also feeds into enforcement. I think that one of the advantages of arbitration is the means to enforce an award, and I think that many arbitrations will be challenged on the basis that the arbitrator has gained substantial knowledge on a confidential basis during the course of the mediation.
Thank you, Philip. Francis will give us a civil law perspective on the very same query of double hatting.
Well, Judge, I must confess that since I'm very much a common law lawyer, I do get some level of indigestion at this concept of double hatting, but obviously it's very common, as Paul has mentioned, in civil law jurisdictions. It's a usual day for them, right? It's unremarkable that you can double hat. And you've heard Paul speak of the cost consequences, especially for small value claims. It doesn't make sense for you to have an arbitrator who is a separate person racking up costs to read into the file as opposed to mediator. But I think the biggest argument the civil law lawyers make is that, a judge such as Judge Kohli or any other judge, in the course of handling a trial, will come across prejudicial evidence. The judge will have to rule on inadmissible evidence, which the judge would already have looked at. It would have gone into the consciousness of the judge, but the judge, being trained, would know how to dissect the parts of the evidence that are inadmissible and purge them from, the forefront of a consciousness when making a decision. So a trained jurist should not fear about double hatting, but that's the civil law perspective. I hand it back to you, Judge.
Thank you. Now, Sachin, the impact of double hatting.
In the spirit of cooperation, I agree with everything that Philip said in his answer. Perhaps just add a couple of additional thoughts from my side. But I think for mediation to be successful, you need to give parties a safe space in which to try and thrash out some form of amicable resolution. And that means there must be that willingness to compromise, to perhaps concede points, to perhaps reveal your strategy to a mediator. And would a party do that if they knew that that same mediator was going to be the arbitrator in their dispute? I think it might have a very chilling effect on the success or potential of a mediation. And then, of course, what if the mediator proposes a solution which one party rejects? Have you lost the mediator, who then becomes your arbitrator? What if you share confidential information with that mediator, which your opponent has not seen and may not ever see? The mediator, the arbitrator, simply cannot make a Chinese wall in their own minds and shut their eyes to what's been said to them. And the disparity of information, if the the mediator is to become the chair of a panel of three, then the chair has a different set of information compared to the others. What do we do about that? All of these factors may lead to a challenge. They may lead to a challenge to the arbitrator, I should say. They may lead to a challenge of the award on due process grounds, potentially even resisting enforcement of the awards on the basis of a due process failure. So I am reluctant and resistant, I think, to the possibility of double hatting for those reasons.
As a wrap-up to this particular query, let me share with you that the Singapore Convention that came into effect on 12 September 2020 expressly permits parties to agree that the mediator appointed by them can switch hats and assume the role of an arbitrator. As per a 2020 research paper published by the Cambridge University Press that involved a comparative overview of how states around the world would have regulated the hybrid process, out of 195 jurisdictions in the database, 59 states, say 30% rough and ready, address situations where the proceedings start off as mediation and the mediator switches hats to assume the role of an arbitrator. In 43 of the 59 states that have elected to regulate MEDAP, the mediator is permitted to act as an arbitrator in the same dispute if the parties give their consent. In a minority of 16 or 59 states that have elected to regulate the same neutral MEDAP, the mediator is strictly prohibited from serving as an arbitrator in the very same dispute. Mechanisms are different because of the vast landscape of ADR culture and legal traditions that embrace different perspectives and practices in respect of mixed role of neutrals The civil law countries, particularly the East Asian jurisdictions, require written consent by parties for neutrals to be appointed both as mediators and arbitrators. Their role will continue till one of the parties withdraws the written consent. This procedural safeguard is found to be lacking in some legislations, including the Chinese legislation. Talking of Japan's arbitration laws of 2003 and JCAA arbitration rules, the mediator in a dispute can go on to act as an arbitrator in any subsequent arbitral proceedings arising out of the same dispute, and any mediation settlement that may be incorporated in an arbitration award. Further, a safeguard to ensure confidentiality is that no disclosure is required to be made by that mediator to the arbitrator under the Japanese arbitration law. This scenario is different as against this. The common law jurisdictions such as UK and USA tend to be skeptical about neutral changing roles during the course of resolving disputes. In USA, there is a domestic variation on MEDARB that requires combined processes where a clearly written agreement signed by the parties can set the process into motion, whereby an unsuccessful settlement morphs into a de facto arbitration, provided the same is done with informed consent. The common law jurisdiction built upon a predominantly adversarial system rather than an inquisitorial one with respect to disputing parties has some apprehension in the confidential information being shared by the parties during caucuses. In this, MED and ARB neutrals rolled into one. Then under the Hong Kong AGs, the mediator is obliged to reveal any and all material which is confidential and obtained during mediation to the arbitrator. A similar practice is seen in Australia, which raises concerns about the confidentiality issues that have been highlighted by the panelists above. So that is as far as the second query is. Coming to the third one, how effective is mediation in the respective jurisdictions and what can improve it? Francis is going to give us the Singapore perspective and the conventions.
Now, as you can imagine, it will come as no surprise to you that in Singapore, mediation has been a runaway success. Most of the court-funneled mediations go into the Singapore Mediation Center, SMC. Their statistics is that 70% of the cases funneled to them are resolved. 90% of them are resolved within 1 day. They have a sister organization in Singapore, the Singapore International Mediation Center. Their figures, generally speaking, they say, are roughly between 75 to 90%. And so you need to bear in mind that there are really two types of mediations. One is pre-trial, and one is post-trial pre-appeal. And as no surprises that appeal mediations are generally less successful. And these statistics lump up both appeal, pre-appeal mediations and pre-trial. So I suspect that if you were to dissect them, the pre-trial numbers by themselves would be much higher. Back to you, Judge.
Paul will give us a UAE perspective, please.
Thank you, Judge. So yes, mediation in Dubai. So I've been practicing here for almost 10 years, and when I left the UK to move over here, mediation was already quite an established form of dispute resolution, and it was not really off the ground here when I first arrived. Unfortunately, 10 years later, I don't think there's been much by way of improvement. Obviously, timing-wise, it's a useful discussion because the UAE became a signatory to the Singapore Convention, so the political will is there to improve mediation in this jurisdiction. But I'm just going to talk about my experience with clients here, and there's still this lingering suspicion amongst clients of mediation. They, no matter how many times I tell the client, they still think that it's somehow binding on them, and they have to take whatever the mediator finds. I'm very suspicious about giving away strategy. Now, understandably, if you're having a mediation close to trial, that is a legitimate concern, but early on, then you just need to know that what you tell the mediator, if you tell the mediator not to tell the other party, they won't. So that's a couple of the issues in terms of attitude towards mediation. There's also a peculiarity of the market here, and I'm talking about here the sort of the civil courts, not the IFC courts, which is, it's mediation's encouraged there. In fact, it's a practice direction which makes it at the discretion of the court can order them parties to go to mediation. But sticking with the civil courts, there's no concept of without prejudice. So if you're trying to explain to clients who are who've grown up in this jurisdiction where, effectively, if you make an offer, a without prejudice offer in a local dispute, then don't be surprised if that letter ends up in front of the judge as an exhibit, as an admission of liability. Seriously, that does happen. So you've got this whole issue around without prejudice, and it doesn't exist. So you telling a client that they can tell the mediator whatever they want and it's all kept privilege is difficult for them to understand. And the irony is that mediation under a different name has been ongoing here for decades, if not centuries. There's this concept of the Majlis where, before Dubai was invaded by tens of thousands of lawyers, businessmen would convene in the Majlis, so an area of community, of family, and also to resolve disputes. It's somebody they respect and trust. They would, after pleasantries and dates and tea, they would then get to the matter in hand, and they would try to resolve the dispute amongst themselves with a trusted individual acting as a mediator. Now, that's not as common anymore, but there is a certain irony that in a place that is used to this kind of mediation process, that the actual word mediation remains a dirty word here.
Right. Philip has a UK perspective to the same query.
Whilst I don't have any of these statistics to hand, I think that most of the providers of mediation services would say that the prospects of success of settling a case at mediation are high. That may well be 70% or more, that either settle on the day itself or shortly thereafter. Often the mediator is encouraged or encourages the parties that they should retain their role for a period in time to try and see whether the dispute can be settled. But moreover, I think that one of the main advantages of mediations is that the parties themselves are still in charge and can determine what actually happens during the course of the mediation day. It's a very flexible process, and they really feel as though ultimately that they will decide whether the case should be settled. And often I'm finding, certainly with cases in the High Court or judgments in the High Court or arbitral awards, the client themselves feels quite alienated from the ultimate decision. And I think that is one of the main advantages of mediation, is that the parties themselves are still determining whether the case should be settled or not.
Right. So, MERAB, for your information, has seen growth in countries like Canada, Turkey, China, Hong Kong, Singapore, India, Brazil, particularly in industries where arbitration has been widely accepted and adopted, like commercial disputes, construction disputes, labor and trade disputes. Incidentally, in 2020, the Singapore International Dispute Resolution Academy survey, according to that, the process of combining mediation with arbitration as a hybrid ADR mechanism for international commercial disputes was the third most used dispute resolution mechanism. Between 20 to 30% of the global ADR caseload is resolved by MERAB each year. In the last year, 2021, Queen Mary University of London had published an international arbitration survey where 56% of the sample pool preferred international arbitration in conjunction with an ADR tool when it comes to resolving cross-border disputes. So in many cases, there is a contractual mandate to use ADR, typically through a multi-tiered escalation clause. And even when there is no contractual requirement to do so, interviewers, interviewees confirmed a willingness to explore suitable alternatives to resolve disputes. Coming to the last query, which we thought would be of interest, should there be a universally accepted mediation protocol? What do we need to do to forge an accepted protocol for mediation? I'll repeat the question for the audience. Should there be a universally accepted mediation protocol? If so, what do we need to do to forge an accepted protocol for mediation? Sachin, your reply.
I think a framework can help shape a mediation. I think some of the major arbitration institutions have their own separate mediation rules which can guide a mediation. But I don't think I'd be in favor of a straitjacket, inflexible protocol which must be applied in each and every case. I think one of the beauties of mediation is its flexibility and the ability for the parties and perhaps the mediator to shape the mediation as they see fit, whether that's in the nature and number of the statements that are provided to the mediator, the amount of information that's provided, how often they meet, when they meet. I think the more flexibility that there is, the better. So I think a framework can help, but perhaps not, in my view, a straitjacket protocol. I'll perhaps leave it there, Judge.
Okay. Phillips would tell us something about his response to the query.
I don't object to some form of protocol that deals with mediations from a high-level principle perspective. The principles could be set out of independence, impartiality of the mediator. I mean, an interesting question which I think has come up during this panel discussion is the status of without prejudice discussions, because certainly in the UK, that's absolutely fundamental, that one can have without prejudice discussions with the mediator which are not told to the other side unless that party gives express permission. So whether a protocol or a principle can be set out might have some resistance, certainly in relation to without prejudice communication.
Thank you, Philip. Francis will give us a treaty perspective to this query.
I think from a treaty dispute point of view, the argument for greater clarity of procedure is quite pressing. In our experience, when you have, especially on the government side, you typically have a problem taking instructions, clear instructions on what to do in terms of a mediation. And you don't want to have that compounded by line instructions that you have to take on every step of the mediation as you're going along. So it's much easier to have clarity of procedure. Typically, on the government side, you're dealing with a multi-ministry team, and it's difficult enough to get consensus on key points. So certainly, I think the need for clarity and certainty is greater. And we have a lot of protocols and codes in arbitration. In the arbitration world, there are many institutions, ICA and so on, have rules. But that's not to say you're straitjacketed, right? So rules can be implemented or framed in such a way that it allows for flexibility, but there is still clarity of process so that one is clear every step of the way how you go along. So I agree with Sachin that there needs to be flexibility, but that can certainly be built in so you can have a balance as in arbitration. Thank you, Judge.
Thank you. And just some information to share with you, knowing that there are arbitration centers and institutions that come up with rules and model step clauses for MEDAP. For example, in 2021, the Istanbul Arbitration Center published rules governing MEDAP that have become the world's first institutionalized written MEDAP rules. The Saudi Center for Commercial Arbitration provides for a model step clause where parties first try to resolve their disputes by mediation administered by the center in accordance with the mediation rules, and if a settlement is not arrived at in 45 days after service of a written request for mediation, The unresolved disputes can be settled by arbitration administered by the center. In Canada in 2019, the new MEDAB framework with new rules, practitioner designations, and templates for MEDAB have been introduced, which shows its willingness to go the MEDAB way. In India, it's work under progress in the sense that we have the comprehensive mediation statute that is under discussion in the parliament, which will be an umbrella enactment, if it is hopefully will be minted soon, and would cover all aspects of mediation, and the subjects which will fall under mediation will be preferred, which is not permitted or prohibited even under mediation, how will it be formatted, what will be the timelines, and all that will be worked out in that. Recently, last year in 2021, a working group of the International Task Force on Mixed Mode Dispute Resolution had set itself the task of creating new practice guidelines for situations in which a mediator changes roles to function as an arbitrator, or an arbitrator performs the functions of a mediator, as in single neutral MEDAB, ARB-MEDAB, or engages in settlement-oriented activities. To wrap up, just to conclude the session, we find that although the MEDAB processes have inspired much commentary and have been enjoyed in many parts of the world, in economies large and small, procedural models are still in short supply. Matters get further complicated by the divergent cultural and legal traditions and laws that prohibit or place severe limits on neutrals performing mixed roles. The demands of ADR indubitably call for increasing innovative and practical solutions. MEDAB and its hybrid are potent answers. With trained and skilled mediators and arbitrators, the attendant ethical issues could perhaps be minimized so that parties can benefit from this process that may be conducted with a single neutral or a separate neutral. It is true that MEDAB does not work in every case, but it can be useful in situations where time and litigation costs matter. A significant percentage of experienced dispute resolution professionals believe that in appropriate cases, if approached with due care and caution, switching hats may be a valuable component in their toolbox, cutting down on time and cost of the dispute resolution. As I said, it's work under progress by and by, with more parties opting for MEDAB. The process, there would be more clarity and a broader acceptable framework that could be adopted as part of the international practice. Thank you. That wraps up our session. We hope we can factor in a couple of questions if anybody in the audience would like to ask one. If you would, to raise your hand and the mic can be given over. Is there a query? Yes, please.
Good evening, everyone. My name is Lav Virmani. I'm a lawyer working with Singh & Singh Law Firm in New Delhi. My question is to Honorable Justice Hima Kohli. Ma'am, you just read out Section 12A of the Commercial Courts Act. Ma'am, Section 12A requires that mandatory pre-institution mediation for suits only where no urgent interim relief is required. However, ma'am, the challenge is that most litigants and litigators, rightly or wrongly, believe that their own cases require an urgent interim relief. So, should there be a specific criteria to decide what would be urgent interim relief so as to effectively implement this provision? Or should that be left to the facts and circumstances of each case?
Mr. Birmani, we all know in the Indian context, when we talk of an interim order, the balance of convenience, irreparable loss and injury, and the criteria laid down for what would happen if the whole basic structure of the dispute goes away, weighs with any court in a jurisdiction. So simply filing an application for immediate urgent relief would not necessarily translate into it being treated as urgent. Perhaps the court would always have and should have the discretion to decide whether that application is simply convenient way of slipping and wriggling out of the pre-institution mediation, or a party genuinely requires an interim order which entitles it to bypass that particular route and come directly to the court. So again, each case would have to be taken on its own merits to see whether it really requires that kind of a relief or not for bypassing mediation. Thank you. Yes, we have another query right next to Mr. Virmani.
Good evening, panelists. My name is Atya Chawla. Thank you, firstly, for a very engaging session. I think we enjoyed this format of getting to hear from everyone. This panelist spoke in detail about double hatting of neutrals. My question is more about the role of lawyers that's played in the process. Specifically in arbitration proceedings, we always believe the role of lawyers is indispensable. But when we look at mediation, lawyers are considered, their role is considered avoidable or even detrimental to the case of the parties. So what would be the panelists' suggestions on how should lawyers effectively balance these roles to best protect their clients' interests?
Can I ask you if this question is thrown at any one of us, or should I request one of us to address you on this?
It would be open for the panel, however.
All right. Maybe we can have Paul to start with on this question and then give an input.
As I understand the question is, what can we do to ensure that lawyers don't disrupt the mediation process effectively? I mean, one option would be that, maybe if the lawyers are behind their position statements, in mediation, often position statements are put in by either side prior to the mediation, which sort of sets out your case, and it saves a lot of time on the day. I guess one question is whether does the presence of lawyers there at the mediation on the day hinder or assist? In my experience, we assist because we tend to, not in every case, but we tend to take the emotion out of it a little bit. I've often had to intervene, and when they try to bring all parties together at the beginning of the day for the plenary session, I have in the past, probably in 50% of mediations, asked that we don't go ahead with that session because it would just start the day on a bad note when they start mudslinging. So yes, I do think lawyers have a part to play in the actual mediation on the day.
Sachin, would you like to answer that question too?
I'll adopt the politician's answer, which is I think it depends. I think in certain mediations when the goal really is striking a commercial deal in the context of a broader relationship, perhaps in the context of other projects as well, I'm not too sure that we as lawyers add too much value in striking that deal. It really is a very commercial discussion where, sure, we can add our advice, but really comes down to the commercial business people to strike the deal. Where I think we can add value is where the issue that's really separating the parties is a legal issue, where you have an evaluative mediator who is perhaps inclined to provide an opinion one way or another as to where that legal issue might ultimately rest. There, I think it's not just useful, but perhaps important for lawyers to be present and involved to ensure that their clients are, best represented in the context of any such mediation. So I think it depends on the mediation.
Can I give my take on that? As a votary of mediation, I have noticed, and on the judicial side, that such of the lawyers who are trained mediators, they add value to the mediation process because they're aware of how it is to be taken further. And many of the matters that go for mediation, because, for example, I'll take Delhi as an example, where we have a very strong mediation center. Every district court judge, the subordinate judiciary, they're all trained mediators. Each one of them are trained. We have a very large strength and a very vibrant set of mediator lawyers. I have noticed that wherever there are counsels for parties in matters that go to mediation, the results are very positive. So it's the mindset also of the lawyer, besides the litigant, that adds that little extra bit towards helping parties. And I'm not saying pushing, I'm saying helping parties and assisting them to facilitate a settlement. That is my experience as on the judicial side, Adya. We saw a query, maybe the last one before we again overrun on that table. Yes, please.
Thank you. My name is Mohammed Amara. I have been practicing law in the region as an in-house lawyer for the last 27 years.
Yes.
I don't have a question. In fact, just a comment on your question for the development of mediation in the region, in particular in UAE. Right. And Philip have limited his answer into only the wish of UAE to ratify the Singapore Treaty. Unfortunately, the fact that mediation have been practices in this region for ages. You just look at the Holy Quran and the text of arbitration. I would like to add that mediation is existing maybe in a different form from how it is practiced in the West. If you look at the labor dispute in UAE, every dispute should be passed to the mediation, sort of a mediation, before the Ministry of Labor, before referred to the court. Dubai decrees, many of them has sort of mediation. And lastly, recently in 2021, in April, UAE have passed a very good piece of law on the mediation in the commercial and civil dispute. So the development here in UAE is,
positive.
Very positive, and we will, by the law, for example, we will have a very robust legal framework to encourage and develop. I would like to add something. Most of the arbitration institution rules for institution arbitration and mediation rules contain many rules regarding mediation.
Right.
So it's not only the fact that we are, ratifying the Singapore, but there is many, many developments.
So,
Thank you.
thank you for the input. As you were saying, it runs in the culture. And as Paul was mentioning, all these mercantile association contracts, almost all trades have that particular contract, which is the fine words written in any bill or invoice which talks of the particular mercantile association intervening to settle matters. And that was just that one-liner that sent parties to the trade to that specialized set of people in whom they had faith to settle matters. So it's not new, it's just old wine in a new bottle in that sense of the term, if I may use. You're absolutely right. Mediation has been there in spirit in many of the jurisdictions, irrespective of whether it was really legislated or brought down into writing, undoubtedly. I think now we are really going to delay the next session if we continue. So thank you so much. It was such a pleasure, and what a lovely audience. Thank you for keeping it going.
Thank you, Justice Kohli, for conducting a very, very lively session. A lot of food for thought for how mediation and arbitration can be a complementary process in a dispute resolution process. So, ladies and gentlemen, a big round of applause for the chair, Justice Kohli, and our esteemed panelists. Before we move on to the final session, may I urge you, all of you, to just stand for a photo.
Mr. Ketan has given us that certificate, and we promised to visit Sundarban sometime, each one of us, to discover where those 6 trees were and how they're doing, just on the side. Thank you.
Incidentally, we got a third-party audit done once, so the trees are there, ma'am. So, ladies and gentlemen, we bring you to the last but the most unique session of today's conference. International arbitration, its interplay with civil and common law. So may I invite the chair, His Excellency Justice Shamlan Al-Saveli, as the chair of the session, along with the panelists to come up on the dais. Ladies and gentlemen, I don't think that I need to introduce Justice Shamlan in Dubai, but yes, I will nevertheless give a very brief introduction to people who have come outside Dubai. His tremendous expertise in international, commercial, and financial litigation in common law, civil law, as well as the Sharia legal system. Justice Swaleh has more than 10 years of experience as a judge at various levels before being appointed as the Chief Justice of the DIFC and the judge in charge of the Arbitration Institution in 2020. Prior to this, Justice Swaleh served as the Director of Strategic Affairs at the Executive Offices of His Highness Sheikh Mohammed bin Rashid Ali Maktoum, the ruler of Dubai, when he was involved in the handling of strategic legal cases. Please welcome him and his esteemed panel members, while I request Mr. Khetan to present him with a green certificate. Yes. What is that? Oh, you seem to have misplaced. Mr. Khetan, the traditional Lothario as well. Yes. Excellency, may I request you to start the session with your keynote and take the session forward. Thank you.
Thank you very much. Actually, thank you for inviting me and my colleagues to this event. Distinguished colleague we have today. It's a very important session, even if it's been listed in the... Oh, really, sorry. I thought it's, okay. It's a very important session. As I said, it's talking about globalization and wonderful subject we are talking about. I will use my habit as a judge in the court. I will speak less and listen more with my counsel. So I just want to give a very small introduction about how it goes and how it's work. I mean, in DIFC, where I come from, and in UAE. Arbitration has been practiced in Dubai and UAE from long time. UAE court went through difficult stages to be a friendly court to arbitration. You have a civil law and common law jurisdiction in UAE. We see the common law jurisdiction is growing in Dubai and Abu Dhabi and in Qatar, as you can see. The advantage of common law system or judicial system being noticed by the government in this region. So actually, it's very important for the commercial industry to notice that which choice of forum they will decide whether arbitration or litigation. But having said that, I think I don't want to take too much time of introducing the idea. The idea, I think the subject matter of today is very clear, speaking about the treaty, how it is the challenge and the benefit of the Indian-UAE treaty, supporting the foreign award, how it is common law, civil law system work together in this region. As I said, respecting the gender balancing, I think we need to start with the ladies first, then the men follow, and I think we'll need to kick off the subject matter. So please go ahead, Your Excellency.
Thank you very much, Judge. Indeed, it's an honor to be here and to be part of the Dubai ICA function of the era of globalization. And I think indeed we have covered a lot of territory in arbitration. The current one, the subject being the common law and the civil law divide, or the bridging the two between each other. And frankly, I'll tell you one thing, to come to the crunch, as we say. I'll come to the treaty after a short time, and I know Hari is going to be addressing on that considerably, but nonetheless. So I think the fortunate part is firstly, that the treaty itself has come into being of a recent origin. It's the first time with a civil law country that India has entered into an international treaty on enforcement of foreign judgments. So I think that is the biggest confluence of common and civil law that we can have, because the minute you start recognizing a decree from a foreign country, the enforceability of that and the trade and the business between the two countries enhances to a considerable degree. And I would like to share with you that last night when we were talking, in fact, the next month over, there is a proposal to take the subject even much further and to discuss as far as the enforcement of foreign awards is concerned, not only foreign judgments, because so far it's judgments, and there will be some more issues on that, and I know that Hari will be speaking about it to some extent, so I'll leave that for him to talk about. On the other part of common law and civil law, we are a common law country. India is a common law country, and we ultimately have dealings with civil law countries, France, Germany, the European culture, Latin America. So you have several other jurisdictions. So traditionally what we came up with, difference between the two. So common law principally, the principle of stare decisis, to follow judgments and the principles that have been laid down in those judgments. And civil law principally to be a field whereby you took down statutes and regulations and everything was prescribed. But I must say that this very traditional difference between the two has really ultimately almost been eliminated in the field of arbitration. And there's a reason. Because arbitration, we have the flexibility to ultimately devise our own procedure and to lay down our own procedure and to define the guidelines. And there is no set procedure for the arbitrators to act. So for example, let's talk about a reasoned award. Now, for purposes of most discussions, a civil law jurisdiction thinks that a reasoned award is very important and imperative. And in the absence of a reasoned award, you can actually have an irregularity which will go to the root of the matter and therefore set aside. Possibly to that extent, common law doesn't feature reasoned award in that high a degree of consideration as civil law does. But having talked about that, when we look at the common law jurisdictions such as ours, principally we not only have reasoned awards, we have detailed reasoned awards. In fact, the awards run into volumes at times, and ultimately as a practitioner of arbitration, you find that you really have to go to a plethora. So when we do an arbitration matter, we actually have to sit down for days on end and conferences on end before the matter can be prepared, considering the lengthy issues. And frankly, if you look at it, there's another viewpoint to it. Generally, the law all over the world now, and India is increasingly moving in that direction, is to have minimal interference in awards. So when there's minimal interference, one, and secondly, where two views are possible, then interference should not be there in the award is the principal idea behind arbitration, to give a finality. But nonetheless, there is reasoning, there is adjudicatory processes. In India, we have ultimately petitions to challenge awards under Section 34, for example, or in the case of foreign arbitration, Section 48, which is a different part. Domestic is different and foreign arbitrations are different. So there is an adjudicatory process. So the adjudicatory process ultimately almost mandates that there should be a reasoned award at the bottom of the line for purposes of ascertaining whether indeed there was reasonable logic and rationale for the same purpose. So coming to that confluence principle again, whether it is civil law or whether it is common law, for example, in the field of recent awards, you would have principally a completely defined line. And on the second part, I was talking about precedents and stare decisis, which is one of the paramount differences between common law and civil law. Again, the principle of precedence is something that is being followed across almost universally in both jurisdictions, in both common law, where it is actually there and defined as such, but in civil law jurisdiction also you do. So today an arbitrator doesn't really take himself or herself from the defined common law principles or the civil law principles, but the principles of adjudicatory process, fairness of law, to devise a procedure which will ultimately meet the test of time. So I think we are reaching a period of consideration where there's a complete confluence of all principles and to take the best principles the way they do come. I would have a couple of comments later, but I will reserve them for now.
Thank you very much for this contribution. Any of our colleagues may want to comment on this before we go to Mr. Ali? You would
Very
like?
well. I think Pinky summed up the conference before we started it. So she has summed up perhaps what we would have wanted to say at the end. But having said that, let me try and increase the divide so that at least we can go on and discuss the issues. So the difference between common law and civil law, what is the difference, and whether the difference is desirable, and how do arbitrators deal with it? So common law principles, one would be that there would be claims, first there will be a claim, then there would be a reply, then there would be a rejoinder. So you have these pleadings. Whereas civil law, both parties would file their responses, and then you would expect documents. Now, one of the most important aspects is discovery. In the common law system, discovery is given a lot of importance, and although we say that we don't allow fishing inquiries and fishing discovery, the difference that civil law people say is that, in fact, we don't allow fishing inquiries, but you do. So the question is, to what extent should discovery be permitted? Because civil law jurisdiction does not, and so there has been an evolution. The International Bar Association rules, there are other rules which have come in place, which seem to now have guidelines. You have discovery, but discovery has to be justified. Similarly, with regard to evidence, should there be cross-examination? Should there not be cross-examination? Of course, cross-examination makes the whole process more tedious, but according to common law, nothing is tested except in the crucible of evidence and cross-examination. So if we look at that, common law plays a lot of emphasis on this, which civil law doesn't. They are happy with statements. Having said all this, that's where the difference, and there are various other differences of procedure, leaving, of course, the arbitrator to ultimately decide what procedure he will adopt. One last line in this opening, that 60% of arbitrations are with regard to disputes in common law countries, and therefore this emphasis of following the common law procedural law. Thank you.
Thank you, Mrs. Batra. One of the famous, I would say, or the most experienced Emirati lawyer, Mr. Ali Zaroni, who practicing in civil law and in common law, the ICA and Abu Dhabi Global Market. Mr. Ali, what's your view on this, and what's your experience when it has come to common law, civil law jurisdiction in arbitration practicing?
First of all, thanks for Fiki to invite us to be among the prominent panelists here, and I'm really working. Maybe the woman is more in power, so I would use the woman. So first of all, thank you for inviting me to be among the prominent panelists here. Uh, Everybody know here, most of the people, the audience, and the panelists know that the Dubai always was a place of middle of the whole business world. So, and UAE also is, as well, of course, as a country. So we in Dubai, sitting here on UAE, we are facing really a difficult situation because we are a global country. We are dealing with a lots of business from all the part of the world. It's actually Dubai become like a center for, hub center for every business people from all continent. So the difficulty always was, being the civil law jurisdiction in UAE, how we can deal with these all transactions happen worldwide, where lots of these kind of agreements and deals going through Dubai. So how we can make Dubai it's a place of a friendly jurisdiction for a civil as well as common law, because we don't want the common law people to get upset on the country here that we are not applying. So that is an investment, and business always goes hand to hand with the legal structure and legal infrastructure, let us put it this way, and how it's helped the business people to doing their deals and settling their dispute, if any. So I think the government done lots of efforts, try to shrink the difference between the two systems. But as, of course, the people who work on the civil and common law, they know that you cannot bring them together because that is impossible. Two systems, it's work differently. Even though the UAE tried to change the civil law and try to make it more easy, lots of parts of the UAE law, even in the procedures, become very close to the common law. But again, it's two systems. You can't bring both of them and make them as one. You cannot merge. It's very difficult to merge it. So Dubai, of course, and UAE come with initiative. Always they're trying to make things happen. That's why we came in Dubai, UAE. We have today a DIFC as a common law, and we have an onshore court. It's a unique situation today. And always when you have a two system and you have two, let us say, different set of court, always a practitioner, they will say, well, that's good for us because we will create a fraction between the both system, then we can play in between the two systems, right? That's always will happen. We are a lawyer, we always use that in the beginning, right? That is why I think the beauty. Today, the DIFC authority and DIFC court especially, and ADGM also after that, they try with working with the onshore courts, try to make both courts work together to complement each other, to give a service and a way for all business people, and also to make Dubai and UAE as a center of the dispute resolution. How you want all global companies try to approach Dubai and the IFC court or ADGM, try to use these tools to enforce their foreign judgment in the Gulf region and in Arab region also, because we as a UAE has a lots of agreements between the GCC countries and the Arab world countries. So we have to come with a solution. The IFC done a lots of good job, and I can't compliment them because His Excellency Judge Shamlani he's sitting in the panel. But I think based on my practice, I saw a lots of a change happen, which make the harmony between the DIFC and the onshore court more close to each other, so they can work together. And also it's create a nice channeling for a foreign award to be recognized, whether it is an award or a judgment came from a common law countries or a civil law country. So you can use both. You can use a Dubai court to be using the tools of DIFC court, as well also a DIFC using a civil law court. So it is in a practice help a lot of international clients who has an international foreign judgments, and they want to execute it on the Gulf region, for example. They can go through the DIFC, and DIFC will sort of facilitating that. That is something very unique happening here. Then, of course, there is some people, they like it, there is a lot of challenge will happen, but look at it from a future vision, which is our leader always, they teach us to look at the futures. Don't look at your toes on your feet. You have to look at futures. Don't let anybody else to stop you of developing the legal system. Always, the legal system always very slow in development, but I think that won't work with the futures. So that's happened today. Even the civil law, with a cabinet decision, they make a very quick way for executing the foreign judgment and foreign award judgment. So that is also, it is an initiative on the civil law, how you can execute it in a short period. Because as usual, today, what is the important for the business sectors? That's if they go for to litigate or they go for arbitration, they need a result. They need the execution. How fast they can do it. The clients always telling us, we fed up of having an award which take us years, then another years for execution. Okay, we need to reach the execution quickly. So the civil law system in UAE with the federal governments, they work very hard to come with a fast track system. Also with their agreements with the DIFC, where they can execute the foreign judgment, also from the common law. It's make it so easy, because in the previous was almost impossible to execute the foreign judgment coming especially from the common law. So that's actually, it is very positive, and I think so it's make really our area here a good example of trying to work both system in such a small country. Okay, that is what I think as a practitioner. And I don't want to elaborate because Harry and others, they have a lot to talk about bilateral. Thank you.
Thank you, Mr. Ali. Actually, I just want to comment before we move to Mr. Amit, that in UAE, the common law has influenced the civil law. Before a couple of years, we don't have the concept of case management system. Now we have it in the civil procedure. When we met first with the previous Minister of Justice, who was educated in Harvard and UK as a PhD holder, he told us, look, I cannot introduce everything in common law to the civil law practice, including cost recovery and oral hearing, which is missing until now, the civil procedure, but at least he introduced the case management, which improve a lot civil court system. One of other things for arbitration, the interim measures have been introduced in UAE arbitration law, and recently in the IAC rules, Dubai International Arbitration Center, where I sit as a court member. So we have a new set of interim measures being regulated. On the UAE arbitration law, now you can ask the Court of Appeal in UAE to recognize the local award on ex parte. We don't have that concept of ex parte before. Now you can do it. This is an influence came from the common law concept. So I think this is a good time to speak with, to give Mr. Amit the contribution, because he has a lot to share with us in this regard. Thank you.
Thank you, Your Excellency. I realize we're on the graveyard shift here, so I can't think of a better way to use this time than to launch into a history lesson. If I may, we've heard a lot about the India-UAE treaty today. The ambassador mentioned it in the plenary session. The Chief Justice mentioned it. You just mentioned it. Now, what I found funny was people saying, "Oh, this is a recent treaty." It's 20 years old. Over 20 years old. It was signed in 1999, and for what it's worth, it's called the Agreement between the United Arab Emirates and India on Juridical and Judicial Cooperation in Civil and Commercial Matters. It's quite a mouthful. It was signed in 1999, ratified in 2000, provides for mutual reciprocal recognition and enforcement of civil and commercial judgments and arbitration awards, and the service of summons between India and the UAE. Now, when this treaty was signed, the UAE was not a signatory to the New York Convention. The UAE at that time had very few treaties. As Ali just mentioned, the UAE now has a huge arsenal of treaties, bilateral and multilateral, with parties around the world. But back then, the UAE had a very limited set of treaties. But even today, a treaty of this kind is the only one of its kind in the world between a common law jurisdiction and a civil law jurisdiction. And in that context, what I find fascinating is we have had the experience in Dubai of a common law system and a civil law system working together, side by side. And this is going to become very important. The lessons learned from how the Dubai courts and the IFC courts have learned to live with each other, that's going to be very important for the India-UAE relationship going forward, because we've heard today about the comprehensive economic partnership. Bilateral trade is going to go up from $65 billion to $115 billion. So in that, and the ambassador confirmed today that the arbitration notification is going to be issued as well. So the way this treaty works is for each of these elements, the service of summons, the enforcement of judgments, and the enforcement of arbitration awards, each of these elements requires the Indian government to issue a gazette notification. So that notification for judgments was issued in 2020. For arbitration awards, if all goes well, we'll have one within the next couple of months. Once that changes, we're going to see a huge increase in arbitration work with an India-UAE focus. Whether it's Indian arbitration against UAE parties or whether it's UAE arbitration involving Indian parties. In that context, we're going to see much more of these issues that Geeta mentioned in terms of approaches that civil law, common law arbitrators have, and also the approaches that the civil law and common law courts have. And I can list out a few issues that I can think of at the top of my head. The issue of authority, because the civil law requires specific authority to arbitrate, whereas the common law is much more flexible and ostensible authority is enough. Now, we're getting there. The commercial companies law now recognizes ostensible authority, but the federal arbitration law still doesn't. We've got issues with authentication of awards, which people don't realize how difficult it can be for an onshore arbitration award to be authenticated and legalized. Whereas, again, on the civil law side, again, a much more flexible process. So we're we're getting there, and we've got quite a few learnings from the DIFC courts, Dubai courts interface over the last 15 years to draw on. But I have a feeling that there'll be a very steep learning curve, especially for Indian lawyers trying to navigate this jurisdiction, because they don't realize, apologies to my fellow panelists, but a lot of Indian lawyers don't realize how complex a jurisdiction the UAE is. It's a federal system, B, in addition to the federal system, you have the common law and civil law system, and within the federal system, again, you have multiple judiciaries. So, the way I see it, yeah, huge opportunities, huge challenges. But on that note, I want to hand it back to you.
Thank you for this. I think, as you said, we are getting there, but we should acknowledge there is some kind of challenge, especially between the concept, the court approach, if you like, in common law and civil law. I'll give you an example. One of those challenges is anti-suit injunction, where, an example, in the IFC court, we try to support and uphold the parties' agreement of choice for the seat to be in the IFC, and we always prevent the party from continue any litigation suit in Dubai court or Abu Dhabi court or wherever. We issue a couple of order in this respect, and the party failed to respect. We issue contempt of court order, but still this kind of concept does not exist in the civil law jurisdiction. They think this is not a contempt of court. Still the party have the choice to choose whatever court they wish to litigate before, and let the court decide if the court don't have jurisdiction. So the whole concept of support the arbitration agreement in common law, we try and fight very hard to support the agreement. In civil law, they take more like a flexible approach by, no, let's hear from the party first, then we'll decide later on. But again, back to you, Your Excellency, what do you think in this before we jump to the audience, to hear from them if they have anything? Any remark, comments?
No, you're right. I mean, these are issues that concern us, and because Dubai has this unusual feature of an intermix between both of them, obviously there's an anti-suit injunction is something which is fairly frequent and common in common law jurisdictions, including India. Of course, India has had very few. They can be named on fingers for the time being, but throughout the common law jurisdiction across the world, yes, anti-suit injunctions and arbitration particularly are fairly common. And indeed, I think this is something which we need to take a foot forward in civil law too, for the reason that you are encouraging arbitration as an alternative dispute resolution. So obviously forsaking the other route for purposes that parties have accepted, and parties with their autonomy, the party autonomy being the first criteria. So you really have that position where you want the party autonomy to work. If parties have decided they want arbitration, and if parties choose, or one of the parties chooses other judicial forums where they want to proceed on, or even other arbitrations, or simultaneous or concurrent kind of application, then obviously those efforts have to be forestalled, whether it is for arbitration proceedings, whether it is for interim reliefs, whether it is for securing the assets for purposes of arbitration. So I do think, indeed, the very important factor in this is to ensure that arbitration takes precedence where it is chosen by the parties as the forum to litigate and to decide and effectively adjudicate the disputes inter se.
Thank you. You wanted to comment on this before we go back?
So I think Your Excellency's judgment on multiplex was the judgment we, in fact, in the inaugural session also we talked about, where Your Lordship ruled, Your Excellency, the ruling was that you would not interfere, or the onshore courts would not interfere where there was an agreement between the parties. So clearly the way forward if arbitration has to be a success is party autonomy and the courts having a hands-off policy as far as possible and saying the arbitrator is the best person to decide upon his competence as long as there is something clearly there which shows that the arbitration clause is applicable. Now, with regard to anti-suit injunctions also, see this whole, and I said this earlier in the day also, that we must have had some 20 landmark judgments on arbitration by the Supreme Court alone in year 2021 in India. So it's an evolving field, and it's evolving in favor of saying, let's have good arbitrators, let's have neutral arbitrators, let's have party autonomy. And I think Your Excellency's judgment is the way to go.
All right, thank you. I don't know how
Yeah,
much time.
if I may add something to what you just said, as Your Excellency pointed out, the civil law courts have a very limited arsenal of tools. They can't issue injunctive relief. They can't enforce, contempt of court. But the other thing they lack, especially the onshore UAE courts, is the lack of any sort of binding precedent. And also, in terms of explanation of principles, it's very high level. I don't, I'm not saying this just because you're here, but the biggest tool that you have as a common law court is your ability to get the written word out there and get a body of precedent in place, which is, I think, the strongest tool in the arsenal of a common law court. And I think that's where the interface between the Indian courts and the UAE courts, well, not the onshore UAE courts, but the DIFC and ADGM courts, I think that's where there's the strongest possibility of a linkage.
Well, interesting. We have our colleague here. You have to leave because you have a flight to catch up. But I don't know how much time we have for question and answer. Do we still have time? Yes. Yes, please.
Good afternoon, Your Excellency and panelists. My question concerns limitation, because UAE is a very generous, onshore UAE, so the civil law system is a very generous jurisdiction for limitation. I believe it's 10 years for commercial contracts and 15 years for civil contracts, as opposed to only 3 years under Indian law and 6 years under English law. Now, you might have come across cases where, for example, an onshore UAE court judgment would have needed to be enforced, let's say, either in the DIFC or within the ADGM. And if that happens, would you enforce an award or a judgment of the onshore courts, which was, let's say, issued in year 9, and therefore would be outside of limitation within the ADGM or within DIFC?
Right, thank you. Mr. Ali, want to comment on this, or you just leave? Yeah, I don't want to. Right, I want to take like more independent approach. Yeah, no, actually the Dubai decree which created the DIFC, which is DIFC law, it's very clear, yeah, the enforcement of Dubai court judgment or DIFC court judgment without question. We have example of DIFC court judgment being enforced in Dubai, then we have DIFC court judgment being enforced directly in Kuwait and Bahrain without even take any authentication, if you like, from Dubai court. And we haven't seen any challenge in that so far. So the short answer to your question is yes, we have that kind of enforceability between both courts so far. Unless those couple of issues, when I talk about the contempt of court judgment of the IFC court, the problem with that, when we send this to the Attorney General of Dubai, which is in our rules, we have to issue an order, we send it to General Authority of Dubai. The General Authority in Dubai, under the penal code, it's not penalized as a contempt of court. If the court told you to do something and you haven't done it, pay X or don't do this, this is not a crime in UAE law. There is a few situations which will be treated as a crime if the court asks somebody to come and give a statement and he refused to do so, or if you insult the judge or misbehave in the courtroom, this has been a crime. But for contempt of court concept, which is a common law concept, is not penalized in the UAE code, and this is where the challenge is. I hope I answered your question.
I will just comment. I understand Karishma also question is whether the courts who will execute the judgment, they will interfere and use and apply the law, because especially like, for example, is the time bar. Okay, I think, in my opinion, and this is based on the experience of DIFC judgments being enforced in the civil law court, which is Dubai. The Dubai onshore, they will just execute it. They don't look at whether it is applying the time bars or applying other things. So no matter whether it is different, so civil law is too generous on, as you said, on 10 years for transactions. If the onshore court, they issue the decision on that, and in the common law it's a 6 years, okay? The court of DIFC, they will not interfere on the judgment. They will just enforce it. So the enforcement part, it's nothing to do with whether the judgment is correct or not correct within the time or not, because it is correct in the court which they issue it. This is what I understand. I may misunderstand your question, but I think maybe I could touch something.
If I can add to what you said, you know where I expect this to become a real issue? As between India and the UAE, because India has two different limitations for foreign decrees and foreign awards. One is I mean, I haven't practiced Indian law for many years, but I think there's a 12-year limitation and a 3-year limitation, and one of the two applies to decrees and one of the two applies to awards. So depending on which route you go, you could end up with a problem in India. The other way around, because the treaty is interesting. The treaty says, and this is very different from the Dubai Court's DIFC MOU that you mentioned, Judge. The treaty says the enforcement will be in accordance with the domestic law of the receiving state. So, so you could end up with a different, you could end up with a different result depending on whether you're in the DIFC or whether you're onshore or whether you're in India.
But the good aspect of a practical aspect, personally, I enforce some international arbitration award came from India in DIFC. So we have that kind of positive story to tell about the DIFC. I'm talking about my jurisdiction. Any other comments or another
But I just add one thing, Judge, that basically when you execute a decree under a treaty, it is deemed to be a judgment or an award of the domestic country where it is sought to be received. That is why the entire application of the domestic laws would actually stand to order.
Right, but I just want to make it very obvious. When we enforce a judgment came from India or arbitration award seated in India, we don't based on the treaty. We based on the common law to common law recognized jurisdiction. This is because the treaty was existing in 1999, enforced in 2000. The DIFC court came in operation 2005 and 7. So,
and that's another interesting distinction, though, because the DIFC courts or the ADGM courts will look at an Indian judgment or award and go, common law, comity of courts in the case of a decree, or in the case of an award, they'd say New York Convention, the UAE doesn't have a reciprocity reservation, so we'll enforce it, right? Onshore courts, even though there's no reciprocity reservation, they still imply reciprocity. On the other hand, the Indian courts are actually handicapped because India has this requirement that I don't really understand under Section 44A of the Civil Procedure Code, that the country has to be notified as a reciprocating territory. And there's a similar provision which, I don't know who thought up this thing, under Section 44 of the Arbitration and Conciliation Act, where the same rule has been applied to arbitration awards. So it's not enough for a country to be a New York Convention state, but it also has to be notified by the government of India as a reciprocating territory. So I mean, those differences will lead to different results. And overall, I think, and again, not because you're here, but I think the DIFC provides the best route in terms of enforcement.
Thank you for that. Any other question from the floor? Yes, that side.
Hi. I have a question here.
Well, I don't know. Yeah, that's fine. Yeah, I cannot see.
Vivek Agarwal here. I am a lawyer here.
Yes.
My question is for His Excellency Judge. Although this is relating to civil courts, but you are in a position to guide us on this. So, as a lawyer practicing here, we discussed about ways how the civil court, certain things can be adopted to improve and have better justice system, like oral argument and system of precedent. I understand these things may be difficult to implement, but easier thing like legal cost. What about that? This is not that big to implement, I assume. And under the new procedure laws, it is allowed that the litigants can be paid adequate legal cost, but the lawyers visiting from India, they may be surprised to know in onshore courts, the usual legal cost that you get is 1,000 to 2,000 dirhams. Now, why I ask this is, a lot of times I see there are cases which are absolutely black and white. We know which party has made a default, but still they go through the court route because they know that even they lose, they don't have much legal cost to pay, and they get few years or at least few months to pay that amount, which otherwise, if there is a legal cost, perhaps the parties would like to settle. And this seems more relevant in the context of arbitration we are talking. Thank you.
Thank you, Mr. Ali. I think volunteer.
I think I will jump in a little bit here, and of course, Your Excellency is better. But surprisingly, and let me to confirm this, all the people, they think exactly the same. That's the civil law is not allowing to cover the legal cost and the lawyer cost. To be very frank, even before the changes happen now, the law actually is there. It's allowing, the court has the right to award it. But the issue is not having the law or not. It is the practice, the old practice of the judges. It has always been inheritance by another jurisdiction. So that's the reason they are just applying that. That's what we came and we said, guys, the law is not prohibiting, but the application, the judges, they don't want to apply it. In a simple case, which we have it, and it was a labor case, we have an onshore, the court awarded to us the cost of 50,000, which it was our fees. And it was a small labor case. But guess what's happened? In the appeal, they changed it and they put it at 1,000 dirham. Why? It's not about the law. The law always there, but it's a discretionary of the judge whether they want to award 1,000 or 100,000, depending on their what they see it. So, in the law, civil law, it's always was there. They can do that, but because we are not a very old country, we inherited a lot from the different jurisdiction, old regime or old system. This will be changed, and I think so. It will be very close to be changed because the mind of the judges should be changed. Then they will apply. This is what I can answer it.
100% correct. It's heritage from other Arabic judicial system where this cost goes to the advocacy council, not going to the client or party themselves. This is why they order a little fee. But myself being involved in a UAE judicial reform, this is a project being under the process now in UAE. And we are looking to this issue very seriously, especially when it has come to the commercial litigation, not, of course, all litigation. The concept of cost recovery might be introduced. This is just an idea. Yes?
Just one thing, most institutional arbitration does have provision for costs.
Yeah.
The arbitration, yes.
Yes.
But we are talking about now
Yeah.
onshore.
So, but the recovery and the enforcement.
Because
Yeah.
arbitration law, even
Yes.
federal, now actually is
Right.
implemented. Even the act, the new rules
Yes.
implemented.
No, yes. Maybe last question, because I think Mr. Ali, he have to leave, you have a flight. One last, yes?
Hi, my name is Arun. Mr. Ali, you can leave now, sorry, if you want, because it's more an Indian law question.
I will be in contempt of court.
He just said there's no penalties in onshore court, so you might be all right.
Please, please.
I'll be very quick. My name is Arun. I'm a senior associate at Clifford Chance in Dubai. Thank you firstly for a very, very engaging panel session. My question is either to Ms. Pinky or Ms. Geeta. When the India-UAE treaty was finally notified, that was obviously a big, exciting topic out here in the UAE for most lawyers, including Hari and myself. And so we started speaking to a lot of clients about enforcing. There's a huge amount of debt cases and so on where you seek to enforce them in India. So one of the test cases that did go to India, I think it went to Gujarat. What had happened is the onshore judgment here was being executed here in the UAE courts. So the file was still open and the courts were processing the execution. And when it went to India, I believe the Gujarat High Court said the judgment is not final because it's still being enforced in the UAE system. Now, I don't know if that's a quirk because of the civil and common law systems and whether it's a quirk of the UAE court system here, or whether this is how it's meant to be, that if you get a judgment in the UAE courts, which is proceeding with execution here, that somehow is not viewed as final under the Indian system. Sorry, I don't know if it's a very quirky topic.
No, you're right. May I respond to what you asked? It's a peculiar question, but just one question that I have as a counter question to you. When the judgment was sought to be executed in the courts here, then was it a regular part of the process that their execution was sought? Because traditionally what happens is that you have a judgment that you have, which if final, can be enforced. And that's basic Indian law on this subject, that you have to have a final judgment for its enforcement in India. And if it is not final, it will be set aside or not entertained on that ground alone. If it is ex parte, similarly, same thing will happen. If it is in violation of the principles of Indian law, again, that would be a position. There are about four different exceptions carved out in Section 14 of the Civil Procedure Code. So is it a position that the judgment is executed in Dubai or UAE because it is still a subject matter of execution here before you can enforce it there? Because the enforcement would actually follow in the country where the assets of the defendant are located as a general feature. So why was it being executed here for it to go there?
No, because there are assets in both countries.
Oh, I see. Well, if that is the case, it's actually, the position should not be correct to the extent that if the judgment has attained finality, is only part of it is sought to be executed here, because you can have executions in multiple jurisdictions, depending on the assets. So we should consult each other after the panel discussion.
So I can only supplement it by saying that I can't understand the fine print of the Gujarat High Court. But that's all I can say, because obviously that's why we have the treaty. That's why we have it gazetted. So I think that's the simple answer.
Just a very short follow-up comment. One other quirk in the Indian Civil Procedure Code when you're enforcing is there's a requirement to get a certificate from the court that issued the decree saying this is the percentage to which it has been fulfilled. Now, that system doesn't exist here, except I know the DIFC courts, the Rules Committee has just approved the format of such a certificate. So that's going to be another minefield, to say it's been satisfied 30% or whatever.
Well, I think I have to thank everybody, all the distinguished speakers for their contribution. Thank you very much. I think this is the end of it. We don't need Mr. Ali to miss his flight, and thank you for the... Yes, of course. This is why. Yes. Thank you for you.
Tremendous session, ladies and gentlemen. This session has probably been the most representative of what ICA hopes to achieve today's conference. A marker of our friendship with UAE despite the differences in our legal traditions. We hope that the meeting of minds of prominent and common law lawyers like our esteemed panel in this concluding session will bridge any divide remaining in the globalized world. So that calls for a big round of applause for the chair and the panelists. Ladies and gentlemen, some high tea awaits you outside. Let's interact and meet outside.